We have a packed agenda, so we'll get started now. To welcome you to this wonderful building, campus, and event, please welcome the Dean of the McGeorge School of Law, Dean Michael Hunter Schwartz.
Good morning. So today's conference is probably for me, the very worst thing about being the Dean of the McGeorge School of Law, because while you all are going to be enthralled and engaged and think deeply about the last 50 years, I have to do a whole bunch of dean meetings. And so I'm very sad, actually, as I sit here and think, oh my God, I'm going to miss all the good stuff. But I'm also really proud to be partnering with the FPPC and the McGeorge Capital Center, which is really a central part of McGeorge as a law school, our role in the government and supporting the government in California, not just the state, but the cities and the counties, is really a core part of the McGeorge mission. And it's really exciting to be at a moment of anniversaries. So as you may have heard or maybe can see, this is the 100th anniversary of McGeorge as a school of law. It is also, of course, the 50th anniversary of the Fair Political Practices Act and the 40th anniversary of California's Victims' Rights Center, which is on the McGeorge campus. And so it's a big moment for all of us, and I'm really proud to be hosting today's conference. So I wanted to thank you to be in our newly remodeled lecture hall, to welcome you to our beautiful campus, and to thank you all for the important work you do to advance our state. Thank you so much for being here.
Hello, everyone. I'm Erin O'Neill. I'm the director of the Capital Center for Law and Policy here at McGeorge and our Capital Lawyering Concentration, which is a program of study for students who are interested in work at the intersection of law and public policy, which is pretty much where we find ourselves right now for this commemorative event. We are so excited to host all of you and have the FPPC here talking about the 50 years of the Political Reform Act and the effect that it has had on ethics in government in California. I was thinking about this last night. Obviously, the Political Reform Act was passed subsequent to the Watergate scandal in 1974, a time of a great crisis of faith in government, and we find ourselves in kind of a similar position these days in terms of questioning governmental institutions and the ethics involved as such. And so we are excited to be hosting this event and reflecting on what has come thus far and what are the challenges for the future. I am happy to introduce the chair of the FPPC, Adam Silver. He'll give us an overview of the day today. We're so happy to see you all here, and I see a lot of familiar faces and alums. McGeorge is obviously central in the Capitol. We consider ourselves the Capitol's Law School, so thank you for sharing your time with us today.
Good morning, everybody, and welcome again to today's event. My name is Adam Silver, and I'm chair of the California Fair Political Practices Commission. If you're not familiar with our commission, we're the agency charged with interpreting, administering, and enforcing the Political Reform Act, the reason why we're here today. But before we talk about the act, there are several thank yous in order. First, I want to thank Pacific McGeorge School of Law for generously hosting us here today. It's a beautiful building. Thank you again. I also want to thank our esteemed group of panelists for presenting. I'm very excited to hear what they have to say. I want to thank all of you for coming from all over California to join us today in celebrating the Political Reform Act. And lastly, I want to thank all the prior FPPC chairs, as well as commissioners, staff, past and present, for the tremendous contribution that they've made to the FPPC and its mission. Without all of you, the FPPC certainly would not be recognized as a national leader in transparency, accountability, and technology. Today, in my opinion, is a celebration as much of you and your accomplishments as of the Act. So thank you so much for that. So with that in mind, let's move on to the Act. What is the Political Reform Act? Why is it important to you? So the Political Reform Act, that's the body of law that created the state's campaign, lobbying, and ethics framework. So campaign reporting, lobbying rules, gift limits, conflicts of interest, that all comes from the Political Reform Act. And obviously that's important for a lot of reasons, right? Among those is that it created the FPPC, right? So without the Political Reform Act, there wouldn't be an event today with free coffee. I wouldn't have a job, so there's that, right? But more importantly, the Political Reform Act demonstrates that where there's a will, Californians can not only demand, but impose ethical standards on their government, on their public officials to create greater transparency and greater accountability in the political process. And that's an important message. It's certainly something to celebrate, in my opinion, and something that I hope all of you will consider as you're listening to our panelists today. So with that, I'm going to throw it over to California Governor Gavin Newsom. He has a special message for the audience related to the Political Reform Act. Thank you so much for joining us today.
California, in so many ways, prides itself on being on the leading and cutting edge. And in the area of ethics, I'm very proud to say that's no exception. No offense, of course, to the rest of this country, but you may recall it was after Watergate that California reacted, one of the first states to react swiftly, passing sweeping reforms to campaign financing and lobbying and political ethics, all to reassure a rattled public. And now we're seeing, all of us recognize this, some of that same mistrust, some of that same unease that was so familiar decades and decades ago. We're seeing all of these attacks on government institutions as well as officials on the rise all across our country. Transparency was then and is still the best antidote to this mistrust. And that's why we need the Fair Political Practices Commission more than ever. It was for decades now, decades. The FPPC has been the gold standard around the nation, setting the bar high as other governments attempt to, emulate what you have done here. You've made the art of speaking truth to power an honorable task without which we cannot function. The kinds of people drawn to this work are people we need more of. Those with strong values who believe in doing what's right, even when it's hard, and making sure the details are right and that no corners are cut. Your work is hard, and it's often thankless. And so I want to thank you. What you do is incredibly important. So here's to 50 years, yes, but here's to a vibrant and thriving 50 more.
We'd like to thank the governor's staff for arranging that for us this morning. So from our current governor to a previous governor, one of the people most influential in why we are here today. A few weeks ago, we had the privilege of being invited to Governor Jerry Brown's ranch up in Colusa County, and Chair Silver was given the opportunity to interview the governor for an extended period of time about his role, his reflections on it, and his observations. We will be playing a topical segment from that interview before each of our panels this morning. So we begin with the governor remembering, how it all began.
Excellent. Well, thanks again for inviting us here today. You obviously don't need any introduction, but I guess for the sake of future generations, you're a four-term governor of the state of California. You were Secretary of State, Attorney General, Mayor of Oakland. You were also one of the framers of Proposition 9, which became the Political Reform Act. And that created, as you know, the ethics and campaign finance framework for the state of California. It also created the FPPC, so without you, I wouldn't have a job. So thank you again for that. We want to talk about the past of the Political Reform Act, where it is presently, and its future. So we're going to start with the past, if that's all right with you. And specifically, I want to get a better idea of the origins of the act, right? So what was the political climate like? Who were the players involved? What was your inspiration?
There really weren't very many players. I focused on the idea of political reform when I ran for Secretary of State. I did so because I noticed campaign reporting was very, very spotty. People didn't list the names or list the names and the amounts. It was very underdeveloped, I would say. So I started working on that by administrative action as Secretary of State, but then I could see we needed a law. And we're not going to get it from the legislature, although I tried there first. So we had to go to the ballot. And the Political Reform Act of 1974 was written in my office, the Secretary of State's office, primarily by Dan Lowenstein, who became the first chairman. And he and he did the draftsmanship, but we certainly collaborated all the way. And we had another group, the People's Lobby, who gathered signatures, and we also had Common Cause. And they, in their own way, were moving on a parallel course, and so we combined. Not without some tension, because I was a political person running for governor. They were nonprofit organizations advancing political reform. So that's how it started, but essentially the matter was composed and completed in my office. And then that's what became the law.
So who do you think was the most unhappy about it once it passed? Was there anybody who gave you a really hard time? I imagine you got some grief.
Well, the AFL-CIO didn't like it. Their leader, John Henning, denounced it. In fact, he withdrew the support that he had given me and a few other candidates who supported the Political Reform Act. So I would say he was the most visible. I think say labor was the most. Other maybe corporate interests maybe didn't like it, but I don't recall they said a lot about it.
So why do you think that we as citizens throughout time have pursued to place ethical standards on our leaders? Is that something that's inherent to human nature? I know this is a pretty big question, so feel free to demur on this and we can go to the next one.
Well, ethics are built in from the Hammurabi to the Ten Commandments to Solon, the lawgiver in ancient Greece. There are rules. And of course, at the same time, the notion of what's ethical or what's appropriate, people did give gifts. That was very common. You would give something. That was accepted. Then later, it evolved that, well, you shouldn't be buying justice. And so we got stricter about it. And corruption, where the decision maker is influenced improperly, it's a worldwide problem, and it takes many forms. So my thought was the lobbyists was an important thing, controlling lobbyists. I thought they were completely outside any particular law. They had a law, but no one paid any attention to it. Or if they paid attention to it, there were so many loopholes that it wasn't very informative. So I don't think there's mass illegality even before the law, but I thought to win the trust of the people, it would be better that there be real transparency and disclosure. What I now realize, looking back, that government has so much power. In fact, government is about power, laws, regulations, and those enactments can affect the flow of money. An oil company, a labor union, business, Disneyland, developers, all are affected by the rules. And they're affected at their bottom line. So they're going to be advocating as best they can. So money, one way or the other, is going to seek to influence government. And as long as you've got capitalism and democracy, where the elected officials need money to run, you're going to have powerful money seeking ways to shape legislation and rules so that they benefit. I don't think you can take that out. So the idea of transparency was to at least let people know where influence was derived from in terms of the money.
And I loved your idea of limiting expenditures as a way to flatten the field.
Yeah, I thought expenditure was a very important way, but the court struck it down in Buckley v. Vallejo, one of the first big cases on federal campaign law. So I thought controlling the expenditures was more than contributions. I never thought contribution limits made a lot of sense. It's too difficult to enforce, and I've used $100 limit myself. I was able to do it. And now with the internet, it's easier, but you need a certain amount of money, and when you put limits, you just invite people to try to get around it. So I didn't think the limits made any sense. That came about 10 years later. And somebody gives you 10,000, 50,000, you can see it. And now, of course, with the way the Supreme Court has ruled, it's unlimited. It's just as independent. So you can't give it to the candidate, but you give it to committees, and these committees are more and more collaborating. Or if they don't collaborate legally, they're working in parallel ways that advance the candidacy or destroy and oppose the candidacies they don't like. So the limit on money is going out the door. And once you say you can't limit expenditures, then Katie barred the door. And so now you have Elon Musk saying, I'm going to spend $150 million. You have Howard Ham from Wyoming saying he's going to raise $1 billion from the oil companies to reshape the energy and environmental policy of the country. So, boy, that horse is out of the barn. And how we correct it, well, you do, I think, through accountability, through transparency, reporting. That's the agenda for now.
And our first panel looks at how the Act and the FPPC came to be, and to introduce the members of the panel, please welcome our moderator, founder and senior counsel of Olson Remco, Lance Olson. Lance.
Thank you, Jay. Good morning. I'm very pleased to be here at my alma mater, and also with so many colleagues and friends, particularly the panel. And I want to take a moment to introduce each of the panelists who've agreed to talk about the origins of the Political Reform Act. So to my immediate right is Robert Bob Stern, longtime friend and colleague, sometimes known as the Hammurabi of political reform laws. But Bob, the governor mentioned Dan Lowenstein, but he failed to mention Bob. Bob was election counsel in the Secretary of State's office in the early 1970s and at the time of drafting of the Political Reform Act, and was one of the principal co-authors, along with Dan, in drafting, and worked closely with the governor in crafting the original Political Reform Act. He's had many other accolades and great things in his life. It's in the biography in the program. I will mention that he has come full circle because he's now an actual commissioner in the Los Angeles Ethics Commission, so he's come around now and is enforcing the law. To Bob's right is Chuck Bell, longtime friend, colleague, partner at Bell McAnderson Hilltack for many, many years, now, I guess, formally retired. And Chuck and I have worked together, and I suppose against each other, but I think more often together, even though we're politically at sort of opposite ends of the spectrum, on various aspects of the Political Reform Act and the FPPC, and we'll be hearing more from Chuck in a few minutes. And then finally, Ann Ravel, the end of our table here. And Ann, also a friend and colleague, is a former chair of the FPPC appointed by Governor Brown, and also went on to become a chair of the a member of the Federal Election Commission, and then subsequently she became chair of the commission. And I have to tell this story, Ann, because when you were on the FPPC and you had the opportunity to go to the FPPC and you had an opportunity to go to the FEC, we had lunch. I don't know if you remember what I told you, but I said it was a horrible mistake to go to the FEC.
It was.
And she now agrees with me. She didn't at the time, but she did. So, Bob, let me start with you, since you were there at Ground Zero and drafting the Political Reform Act, and give us a little bit of background, if you will, about what we heard from the governor, but I'm kind of interested from the staff's perspective what was going on.
Well, Jerry Brown first hired me. He said, I want you to write the 3 best possible campaign disclosure, ethics, and lobbying bills you can don't worry, the legislature will never pass them. So I said, terrific. I said, I get to write perfect legislation, or as perfect as I could write. And I wrote them, and he was absolutely right. They killed the legislation right away. And then a group came to us and said, we're circulating a ballot measure. Would you take a look at it? And after a couple of days, I called them back in my office. I said, why are you having the campaign statements filed in Olympia, Washington? I said, this is California. Oh, they said, we copied the Washington State Initiative, and we forgot to change Olympia to Sacramento. And I said, well, not only is that a problem, but you also have some other problems that are unconstitutional here in California. The California Supreme Court has ruled. Why don't you take a look at my 3 bills and take the best parts of the bills and then circulate your initiative? And they came back and said, tell you what, put the 3 bills together and we will circulate the initiative. So Dan and I spent nights and weekends putting the bills together, adding a commission, went to Jerry Brown. Jerry starts going through and says, why is this comma here? And why is this word here? And what does shall mean here? And he said, I want spending limits, and that's what he said in the thing. So that happened. And then the legislature said, oh, there's this initiative passing, maybe we should pass some legislation. And Common Cause said, if you pass through 3 bills, we will drop our support, and we won't circulate the measure anymore. So the legislature passed a very good campaign disclosure bill. Henry Waxman was the chairman, and my former boss, and they passed a good bill. They passed a pretty good conflicts of interest bill. George Moscone, who became mayor of San Francisco, sponsored that, and it was okay. They changed one word from shall to may, which was kind of a problem. When you law students, you know, shall to may is a big deal. And it was local jurisdictions may require their officials to file statements of economic interest as opposed to shall require. Well, since state officials had to do it, we said it was okay. Then the 3rd bill was a lobbying bill, and I'm in the chambers of the California State Senate at 2 o'clock in the morning on the last day of the session, and they're debating the lobbying bill. And Common Cause says, you pass the lobbying bill, we drop our support for the initiative. And one of the elder senators got up and said, I have an amendment to this. You know who has all the power here in Sacramento? It's the journalists and the reporters. I move that we require reporters to file as lobbyists. And the amendment passed, 19-16. And then the Assembly refused to take it up. And so Common Cause said, okay, we will now circulate the initiative. It was because of that one amendment that we are all here. We might not have been here today if that had passed. And Common Cause, People's Lobby circulated the measure. It went to the ballot, June of 1974. It's passing by 70%. And I'm in the Secretary of State's office. I turned to Dan Lowenstein. I said, Dan, I'm 30 years old. Is this the highlight of my professional career? And he said, I don't know. And that was the highlight of my professional career.
Until today, right? So, Bob, I want to ask you, I know you've written a little bit about this, and I've read it, but there was a fair amount of innovation, I think, in the Political Reform Act of 1974, and maybe you could speak to that a little bit.
Yeah, probably the most important was we allowed the legislature to amend the initiative. As you know, if you know about California, it said the California Constitution says unless the initiative allows for amendments, you have to put it back on the ballot if you want to change it. And we had written 18,000 words of very specific language, and we knew that if we didn't allow the legislature to amend it, it was going to be obsolete soon. There's only been one other initiative, I think, before that allowed the legislature to amend it, and now almost all the initiatives allow the legislature to amend them because I think that's really important. And there's another rule, I'll go into the initiative process later, but there's another rule about that. So we allowed the legislature to, and the legislature has amended the Political Reform Act at least 250 times. And probably almost all the amendments, maybe 1 or 2 are not good amendments, but almost all the amendments are good. They have to do it by a 2/3 vote, and the bill has to be in print for 10 days. And that's that makes sure the public knows what the legislature is doing. So that's what we also said that the legislature had to appropriate $1 million plus cost of living to the commission for its operation. And we did that because, again, we looked at Washington State. They had passed the initiative, and the legislature refused to appropriate any money for their commission. And we said, hey, that's going to happen in California, too. We'll require an appropriation. We also, a little tricky part of this was that most initiatives go into effect the day after they pass. So that would have been in June. And then most other initiatives go into effect January 1st to give people time to get used to it. Well, we knew if the initiative went into effect January 1st, that Governor Ronald Reagan would be appointing members of the commission. And we said we did not want Ronald Reagan appointing members of the commission, the first chairman. So we said, let's have it go into effect January 7th, the day after he leaves office. Now, we didn't know Jerry Brown was going to be elected governor. We knew he was probably running, but we had no idea. But we knew we didn't want Ronald Reagan making the appointments. And so the initiative went into effect January 7th of 1975. We also said that commissioners were term limited. We thought that was important. And we also said that we didn't want the legislature to be confirming, because we knew the legislature, if they were confirming members of the commission, would be a problem. So there is no legislative confirmation. And we have the governor appointing 2, the attorney general appointing 1, secretary of state appointing 1, and controller. And we said, and this has happened now recently, if all the members are of the same party, we don't want all members of the same party on the commission. So we said, for the controller's position, if all were Democrats, the controller had to pick from a list submitted by the Republican Party of 3 people. So we had at least a bipartisan commission. So we wanted to make sure it was not a partisan commission. We also said 5 members as opposed to 6 on the Federal Election Commission. 6 is, I mean, even number is a disaster. 5 was important. So those are some of the.
So Bob, you mentioned some of the politics that went into this, but I'm curious, how much did politics influence the drafting of it? And I say that, for example, there are no contribution limits in the original Political Reform Act. You would have thought maybe that was something that would be pretty standard. I don't know if it was in the Washington initiative,
I don't think so. But Jerry Brown, as he said, did not want contribution limits. And by the way, there were expenditure limits on statewide candidates and on ballot measures and on the qualification of ballot measures. It's all in there. A little story I can tell, that Jerry's out of office, I guess. Jerry said, I want spending limits. He said, I want the spending limits to go into effect in November before the rest of it goes into effect. And we said, really? He said, yeah, I'm running for office in November. I want the spending limits to apply to the statewide offices. And we talked him out of it. We said, no, we had the ballot pamphlet going into effect. We designed the ballot pamphlet into effect in November. But we said, it would look too political for you to have the spending limits go into effect before the rest of it did. So the spending limits did not. But in politics, you know, there wasn't that much in terms of, other than that, I think.
So the fact that Jerry Brown was running for governor had no influence on.
Well, it had influence on whether there would be an initiative in terms of his supporting it. But there was going to be an initiative, I mean, without him. I mean, because Common Cause and People's Lobby were the ones circulating it. He actually, they were rivals.
So you would have been filing reports in Washington State, apparently.
Yeah, exactly. Yeah, the Washington State there was a couple other provisions they said they were unconstitutional. But no, there weren't that, I mean, the legislature obviously was unhappy. The politics was really in the legislature passing the bills to try to stop it. I mean, Henry Waxman called me in his office and said, I want to stop this because I don't want a commission. We don't want a commission overseeing us. So let's stop this thing now. And as I said, it was a good campaign disclosure bill that he got through the legislature, and the conflict of interest bill was pretty good. And there was almost a good lobbying bill too. But that was the politics was more with the legislature.
You have written that if you had things to do over again differently, you might have done some things differently. One of which intrigues me was the makeup of the commission. For those who don't know, the commission has a full-time chairman and then 4 per diem part-time members of the commission. And I think you've suggested that we should have just gone with, or you should have just gone with per diem. And I'm curious why you came to that conclusion.
Well, first of all, Dan Lowenstein was absolutely insistent we have a very strong chairman. And he didn't know he was going to be chair, because we didn't know Jerry Brown was going to be elected. But he said we have to have a very, and this is the only commission, I think, in the country where you have a full-time chair and part-time commissioners. I don't think, and there's certainly no other ethics commission like this. And I found that there were some great chairs. Dan Lowenstein was a fabulous chair. The current chair is a great chair. But there have also been some not so great chairs. And they have, I think, too much influence over the staff. And other commissioners really feel out of it. And one of my jobs was to keep the other commissioners up to breast of what was going on. And they were very resentful of the fact that Lowenstein was there for all the meetings and was directing the staff. So I came to the conclusion that I thought it is too much power in one person, and it would be better to have 5 people doing it.
Well, let me ask Ann, because you served as chair of both the FPPC and the FEC. And the FEC, they're all full-time. Do you have any thoughts on whether the FPPC would have been better as a full-time versus all per diem, or did we get it just right the first time?
I think that the way the FPPC operated is much better than the FEC. And having 6 full-time members at the FEC, because you couldn't have more than 3 of one political party also. But because it was full-time for everyone, there were a number of members of the FEC who wanted to make sure absolutely nothing happened, which is what happened at the FEC.
You could be reappointed. You could be reappointed at the FEC, and they wanted to keep their jobs, right?
Yes.
Chuck, do you have a thought on the full-time versus per diem?
Well, I thought about that a lot over the years, and my opinion has changed. At one time, I thought we should have full-time commissioners here with even staff people who could staff them for things that involve, you know, writing a lot of regulations. We talked about that a little more. Having a perspective on enforcement, which I think had they been full-time, even with staff, would have been a substantial thing and would have kind of overcome the insularity of the FPPC and the sort of the closedness of that staff.
So it sounds like you're arguing for full-time, but maybe.
Well, I'm not sure that I'm in favor of it now. It may be, you know, well, one thing I will say about the FPPC that Bob hasn't mentioned is that this was a state general law, and all of these provisions, especially the disclosure provisions, all of a sudden applied to officials at every level. Local officials were responsible for administering the filing of these reports and making sure that they were filed, and from candidates, appointed officials, and all of that. When we were looking at this in the 2010 task force, I think we realized what a massive responsibility was placed on the FPPC for not only well, administering, but also attempting to enforce the law at all those levels of government, with the number of cities and counties and mosquito abatement districts that obtained.
Let me, Ann, did you want to add anything more?
No, I think that's probably
Okay.
reasonable.
So Chuck, I want to, so we're talking about the early days, and you and I were around in the early days. Tell us a little bit about, from the practitioner side, what it was like to deal with the FPPC at that time.
Well, I think it was a big challenge for all of us. Our clients, of course, were more shocked about this law than Bob maybe stated. There was an uproar at the local level. Many people did not run for re-election to local districts because of the conflict of interest laws alone. Campaign laws, again, were mostly disclosure at that point, and it took a lot of work to do this. Now, there was a lot of non-filing, as Bob, I think, has noted, when the pre-PRA was in effect. That, you know, lobbyists had to file certain things, legislators may have had to file things, but they were spotty. They really weren't monitored, and enforcement for non-filing or late filing was non-existent.
Was your impression that the commission was, the early commissions in particular, were sort of dedicated to trying to find solutions to some of these issues?
Well, I think the initial commissions were pretty amazing in terms of their composition. Dan Lowenstein was a stellar chair. Bob was there as the general counsel, but Joe Remcho was on one of those early commissions. My former partner, Colleen McAndrews, was actually a Jerry Brown Republican appointment to the commission, which I'm not sure that has occurred subsequently.
Yeah, it has to be. They have to do that.
Well, that's true.
It's a requirement. The governor appoints two, they can't be from the same party. And
Right.
so generally.
Well, that's right. You're right. In any event, I think that there was certainly a lot of concern about.
Did you want to talk about the CPAA for a moment?
Well, sure. I think one of the things that the PRA really produced was an administrative agency with all of these responsibilities. All of a sudden, corporations, trade associations, candidates were all having to file. Ballot measures were a big thing. And I think the private practice of law really was fueled in terms of fee paying by ballot measures, which were then and remain a substantial financial impact on elections in the state. So the CPAA was formed by a number of attorneys who were dealing with the FPPC on behalf of their clients. We all had our own challenges with enforcement and the enforcement process there. I think we all felt that the public sort of had the view that anyone who was charged with an offense by the commission was a criminal. Now, there could be criminal penalties associated with violation of the act, but in our view, the press viewed them as criminals. And so there were a lot of tactics in terms of filing of complaints against people for political reasons at appropriate political times. And anyway, because of our challenge with enforcement, we decided that it would be good to ally, even though attorneys represented a wide variety of clients, both political parties. There was a lot of unanimity about the need to have a common front in dealing with the FPPC on enforcement. And because of our interest in the regulatory process and all of that in the legislative process, the attorneys got involved in all of that.
Did you want to add something, Bob?
Well, I just want to add in terms of enforcement, one of the problems with enforcement is that people file complaints and put out press releases saying, we've filed a complaint with the FPPC, and they get lots of press over that. And I remember one time where that happened, and we saw there was nothing to the complaint. So we put out a press release before the election saying, complaint dismissed, there is nothing to this complaint, and it made the front page of the papers. And the complaining people came to us and said, why did you do that? I mean, it's not fair. I said, because your complaint had nothing, there was nothing to your complaint, and we thought it was important the public know ahead of the election that there was nothing to your complaint. Now, most of the time you can't do that because most of the time you have to look into it. It does take a lot of time to finish the complaints, but when there are frivolous complaints filed, I thought it was very important to let the press know, the public know they were frivolous.
So, Ann, I want to ask you, did you want to add something to what Bob
Yeah,
just
well,
said?
I think that that's still an issue today when complaints are filed with the FPPC about particular activity. And the public, unfortunately, doesn't understand that that does not mean that there's something wrong that the person has done. And I think that is incumbent on the FPPC to make that very clear, that what the enforcement process is going to be like, because that's still a problem.
Yeah, Anna, but this is a good segue, I think. I wanted to ask you about the political awareness of the commissioners themselves and the staff, since you were chair and you worked with the staff and so forth. When we were prepping for this, I remember Bob said to me that he was the only person in their first commission that had any political experience, which, no offense, but I found that rather frightening to think that there was no one on the staff.
I mean, they were very, very smart attorneys who had not been
Had
involved
no
in politics.
awareness, yeah, and they were regulating the political community. But I'm
Well,
curious.
we were supervising.
Supervising.
Yeah.
So, but Ann, I'm interested in your perspective on that.
Well, I thought that the staff that I worked with at the FPPC, and by the way, for those of you who don't know, I was appointed by Governor Brown in 2011 as chair of the FPPC. And the people that were there, both the enforcement as well as other members of the commission, and I think it's not so much members of the commission, but staffers, they were very impressive, and they were people who were really devoted to some of the ideas that I still want to talk about as part of this, about disclosure and about the ideas of transparency that Governor Brown mentioned, which were so basic to what was the intent of the FPPC.
Well, then why don't you talk about those, right?
Well, I will, because when I was appointed, I had been a Deputy Assistant Attorney General in the Obama administration, and I oversaw consumer protection. And when I came, and other consumer laws, when I came to the FPPC, that part about transparency and disclosure, to me, was central to the purposes of the FPPC, because that was like consumer protection in my mind. Because we know, and Jerry Brown mentioned this, and it's true, that a lot of people, particularly regarding money in politics, feel that it's so problematic, and therefore they do not have trust in our government. And that's the whole idea, in my mind, about why the FPPC was originally enacted. Was really for the interests of the public, so that the public would understand what's happening in government and know who's behind the money. And if I can take a moment, I want to talk about the case that I brought. Is that okay? Is this a good time, or later?
Well, I actually want to go ahead and do that.
Okay.
Let's keep that
I'll
short.
keep it as short as possible.
Thank you.
So in 2012, during a couple weeks before the election, $11 million from a 501c organization, which is supposed to be charitable, called the Center to Protect Patients' Rights, gave money to a PAC in California to oppose a tax measure and to support a ballot measure that would prohibit union contributions to campaigns without following the law in California at the FPPC about disclosure. So nobody knew who these people were, basically, who were giving the money. And as a result of that, and I don't see Gary Winnick here. Oh, there he is. I knew you were here, because we drove here together. But, so Gary and I filed a lawsuit immediately, because what I said as chair to him and to others, we have to get this information out before the election, because if people don't know this before an election, transparency isn't going to be useful later. It's too late. And it was important for the public to know. And as a result, we filed the lawsuit to require them to submit to an audit. It was the first time in the history of the FPPC that this was done prior to an election, to require disclosure. But obviously, we won, which was really important, because it went to the Sacramento Superior Court first, and then the California Supreme Court also ruled on the case. And they said that they unanimously, the Supreme Court heard that case on a Sunday, and they ordered that they had to turn over all their documentation to the FPPC. And as a result of that, I mean, they had refused to do so, but we found out they laundered money, and it went through various committees in California. And we found out that they had laundered the money through the Koch brothers network. And because of that, we required that they all had to disclose this information about where the money went and where it came from. And I will say, after the litigation, the PAC had to disgorge $15 million to the state of California that had been donated, and they also had to pay a fine of $1 million, which was really unique. And because of that, I think both Gary and I were movie stars. I don't know. There's a movie called Dark Money and a book called Dark Money, and they talked about this, and this was a really big issue. And
we'll be signing after the program.
Yeah, no, and it was really important throughout the country, which was the reason why President Obama appointed me to the FPPC.
It's interesting that was about 40 years after the act was enacted, and this was probably one of the most important cases brought by the FPPC.
Yeah.
I want to back up a second. I am going to actually follow up with Ann's comments and Bob's, but I want to ask Chuck a little bit. There's been a lot of history since Bob wrote the political, or co-wrote the Political Reform Act in the past. I think you mentioned 200 amendments or something.
Yeah.
So maybe you could highlight for us a little bit some of the changes over the decades.
Sure, I think some of them are referred to in the summary that's in your program here, and I think on the FPPC's website as well. But in the 1980s, I think the most significant thing that happened were the competing measures, actually went into the 90s, but competing measures that proposed campaign contribution limits, as well as competing over whether there would be public financing or not. Common Cause, and all of that stemmed really from the Supreme Court's decision in Buckley, which said that if you were to, if you wanted to compel expenditure limits, you had to have a public benefit in the form of public financing of partial financing of the campaigns. So Common Cause really came back since the expenditure limits that Jerry Brown had in mind were also invalidated indirectly by that. Came back with an initiative that proposed spending limits as well as partial public financing of the campaigns. That initiative was circulated intending to qualify for the 1986 election, but it didn't have enough signatures to do that without some more extensive work that had to be done with the registrars of voters and litigation. So in 1988, the legislature came back with a challenging initiative, Proposition 73, and in that year, both of them passed, with Proposition 73 attaining a higher percentage of the yes vote. And there then ensued a lot of work. The FPPC got very involved in trying to figure out which provisions of Prop 68 would go into effect as part of the prevailing Prop 73. So there was quite a bit of litigation over that, quite a bit of regulatory action, and the litigation resulted in a Supreme Court decision which defined more closely what the law would be when you're trying to sort out when you had competing initiatives, which was overlapping and would go into effect, which wouldn't go into effect, and so on. That did not suffice with Prop 73 in the lead. It was ultimately litigated, and portions of it were struck by the federal court. But then Common Cause came back with Proposition 208. It was a slightly different scheme. And at the same time, there was a more progressive, if you will, public group that promoted Proposition 212. Prop 208 passed, and there was litigation over that. And before the litigation settled, again, being in the federal district court here in Sacramento, the legislature came back on a bipartisan basis. I think Lance was closely involved with the drafting of that. But it basically repealed what was going to be going into effect of Prop 208 entirely with Prop 34. Actually, there were a few portions of the previous measure and remaining parts of 73 that went into effect. One thing I would say about Prop 73 was in it was a prohibition on government financing of campaigns, and that provision had withstood the various amendments during the whole set of wars between the initiatives on what would prevail in campaign finance. The legislature, a few years ago, tried to repeal or modify that, and a group of us took them to court, and that measure, attempting to repeal it, was struck down as unconstitutional. So Prop 34 was a whole new scheme. It remains in effect. The commission and staff spent a lot of time working through the interplay between those and when one would go into effect, whether money that was held over could be used and continue to be used in future campaigns that were subject to Prop 34. And I think on the campaign finance front, that was about it. Of course, in the 1980s, we had the FBI here and the shrimp scam and all of that. A number of legislators, lobbyists, even political people were caught up in that, and a number of them went to prison for that. As a result of that, the legislature's response was to come back and put Prop 112 on the ballot, and I think that's been alluded to a little bit, but it had limits on gifts that could be made to officials at the state and local levels, honorarium bans, and travel provisions that allowed for certain travel that was related to governmental business. Those are the big ones, and it kept us all pretty busy.
Let me, we've got, I think, less than 10 minutes, and I do have more questions for the panel, but I think I'm going to stop here and invite questions from the audience if there are any. And feel free to raise your hand or however you normally get attention, and I'll try and recognize you. I'm seeing nothing. I guess we were that inspired. All right, we have a question here in the front row.
Good morning. My name is Jeremiah. I'm one of these journalists and lobbyists. I work with Cal Matters, and a few of you spoke about the value of...
Look at the letter.
Yeah, I'll repeat your question.
A few of you spoke about the value of enforcement action before an election, so that the public can know who is spending money and who's acting in the campaigns. What, in your mind, is the value of enforcement actions that take place after an election, after the person has already been elected, let's say?
So the question is, what is the value of enforcement action after the election, after somebody's already maybe been elected to office? Why don't we start with Ann?
Well, presumably that will then taint whoever that candidate or person who is elected to office based on that information at some point. I gather that the value could be, assuming that the decision is to have given that information is true. You know, the value of it could be that that's information that the public will then know about someone who's already elected, and they could be, you know, critical. The press, Cal Matters could write about it, but I think that there's greater value in advance.
I think there is, when we first adopted the act, we thought that the press attention on an enforcement action would be so embarrassing to the public official that they wouldn't do it again. Well, we were wrong. I remember there was one state elected official who didn't file this proper disclosure. We fined him several $1,000s, and he did it again. And we went to him and said, "You did it again, why? Didn't our first action do anything?" He said, "My constituents didn't really care." And so that's a problem. And that's why I think, in a sense, there has to be stronger penalties. And I would like to see, right now, criminal penalties that are being brought are misdemeanor actions. And usually the fines are not that much, and people don't get jail time. My recommendation would be that if somebody deliberately violates the law, that if a DA or Attorney General brought a criminal action, the person would have to serve at least 1 day and 1 night in jail. In my mind, that would be a deterrent for many of these people, just having to go to jail, being processed through that, and having to serve that. So I think the problem with the fines is that they really don't sometimes have an impact. Now, of course, their opponents can use it in the next election, and sometimes that happens. If the fine is substantial enough, I suppose the opponents will make a big deal of it. But I've been disappointed, very frankly, in terms of the impact of the enforcement actions.
Chuck, did you have any further thoughts?
Well, my thought is, as I mentioned before, I think often the purpose of filing the complaints pre-election was to get the press attention. That was when the press was attentive, and with due respect to the people at the state level here, I think the collapse of the press at the local levels, and even, you know, at some of the big papers in terms of coverage of these things, may not make it as important. I do think that, again, there's a thought that the FPPC's actions are criminal in nature to the people who are the subject of the complaints against them. And so you do have some deterrent effect.
All right. Any other questions? In the back there.
Mine is not a question, mine's a comment. As a former commissioner, I served on the commission for 6 years, and I want to speak to what Bob was talking about. My name is Carol Scott. Before Karen became the chair, we as part-time commissioners were kind of kept from speaking to staff unless we made efforts to do so, and were kind of discouraged from doing that, and staff was discouraged from doing that. I found out that there were chairs who told staff not to talk to us. They didn't give us both points of view. If staff disagreed, they were not supposed to be talking to us. I was one commissioner who really supported public disclosure, and I was mocked and embarrassed by chairs. I'll never forget when one of the chairs left. I can't remember who it was, and he said it was a pleasure working with all of you, except for Carol Scott, or some comment like that. So I think, I also agree that there needs to be a change both in money and maybe in criminal enforcement, working better with the Attorney General's office. Also the jurisdictional issues when you have Indian tribes, when you have local groups. I mean, there are lots of things. We worked very hard on disclosure and on conflicts of interest, but I do think there needs to be really a look at what the structure is, and it might be important to bring those of us in who were kind of on the side and realize what we knew and what we didn't know. I was shocked to find out that we weren't being told certain things, and the chair was warning the staff who worked there not to tell us things. And I found out more information. I don't know if either of you remember me, but I found out more information from you guys from Common Cause. And
Okay.
those are my comments.
Thank you for your comment. I did have a question, I believe, down here. So this could be our last question. Or maybe two, I don't know. Depends on Jay.
Well,
Ann wants to answer.
okay,
Yeah,
good.
I just wanted to, in response to the question from the Cal Matters person, the FPPC does a pretty good job with materials on the website about what you need to do and what you don't need to do, what's inappropriate. But I think that a lot of the regulations are very complicated and very difficult for some people, some candidates, to understand what the risks are. And it might be a good thing for the FPPC to spend a little more time trying to help candidates to assure that they're not going to get involved in some sort of penalty.
Okay. Bob, you can get the last 30 seconds, and then we've got the hook.
Well, as I said, right now, there are administrative penalties, there can be civil penalties, there can be criminal penalties brought by the Attorney General or the District Attorney, and almost all the cases are administrative, and almost all the cases are settled before there's an administrative hearing. The big problem is deterrence, and the question is, what can you do to deter people who, one problem is, frankly, 5 to 10% of officials may break the law no matter what, and there's nothing you can do about that. But the 90% of the officials who want to comply with the law, Ann is absolutely right, they need more guidance, and also a fear of the FPPC and a fear of enforcement.
So Chuck wants the last 15 seconds.
Go for it, Chuck.
Well, one of the things I think that the FPPC has been responsive to, and complaints of the regulated community, the Political Attorneys Association, is to expand the number of cases that are subject to what's called streamlined enforcement. And that's a summary process because, you know, there are big cases, and then there are little cases, and then there are minuscule cases. They all wound up in the same tranche for a long time, and they all took a long time. With the streamlined, if you have somebody with a little problem, you can get it dealt with quickly and at a cost that is reasonable, not, you know, $5,000 per violation.
So on behalf of the panel, thank you for your attention.
Thank you, Ann. Thank you, Bob. Thank you, Chuck. And thank you, Lance. That was very interesting and bringing us to the next segment. As we get ready for our next panel on the present, here is Governor Brown giving his thoughts on how the law is working or maybe not working.
So let's move on to the present. Do you feel like the Political Reform Act has achieved the objectives that voters thought it would in 1974?
Well, you know, what do they think? I mean, this is politics, so there's always overstatement. And the idea that we're going to reform government in itself is an overstatement. Mm-hmm. You can change government, you can introduce new regulatory regimes, but can you change the beast? And I'm saying the nature of the business is to create measures, laws and regulations and decisions that channel money. So therefore, money and the custodians of that money are going to want to have a say in what those rules are, and that costs money. These lobbyists cost a lot of money. So the only thing you can control if they get a hamburger or they get a steak, or if the employer pays for it. So did we, I would say the notion of purity of election already was an overstatement. If you look back to the law of the 1870s, did they achieve purity? No. Could they achieve purity? Not in any real sense of the word purity. So today, we have a lot of transparency, and then you have a lot of compliance activity. And so I would say reform, it's part of the process. And I do think compliance at many levels, in education, in business, in political reform, you can get too much compliance. But you can get too many rules that require endless compliance activities, which are very expensive, which are easy to get wrong, and which basically the weak, the not powerful, run afoul of it, whereas the powerful, who are the lawyers, can pay the $500 an hour and get the best representation. So, and if anything, political reform just fits into to our rather unequal society and burdens some unfairly rather than others.
Yeah, I've heard the saying complexity in law is a subsidy to the rich or the wealthy.
Well, obviously, they got the tax code. And political reform is getting complicated. Figuring out your reporting, especially in your personal reporting of assets, can get, if you have complex holdings. Of course, if you have complex holdings, you have money to hire lawyers, so they get it done. But I do think you have to be careful on the small campaigns. I mean, what are we talking about? They're not going to, they're not affecting government that much. So I think you got to take that into account. And it's also a weapon. I believe that the opponents of charter schools got charter schools covered as a way to discourage wealthy people from being on boards of directors. And why you have to report your assets to be on a charter school, I think that's questionable. And it was, I think, done strategic. So I don't care whether it's a Political Reform Act or whether it's CEQA, law can be deployed as a weapon in contexts that the creators didn't really think through. So that's where we are.
So I was going to ask you, and I've heard you say several times, you know, more isn't necessarily better in the context of government. And it sounds like you feel the same way about aspects of the Political Reform Act.
I do.
Reform 7.
More is not better. Better is better. The optimum, not more, but what is the right amount? The optimum. Not too much, not too little. What do you need? And what is needed for so you got to know, what are you trying to achieve? So even the Political Reform Act, it could be reformed, should be reformed, should be thought about, should be criticized. Same thing with CEQA. We keep talking, trying to change CEQA. Once you get the damn thing in, courts take it to a higher level. I mean, take it to, you know, when Reagan signed the California State Environmental Quality Act, it didn't apply to private projects. The Supreme Court did that in a 5-2 decision. So now it covers a lot. So now they got to reel it back, and you have to have a lot of exceptions. So it's not the same with political reform, but there's an analogy there. It's worth thinking about.
So you also talk about living within your means. So we obviously have limited resources as the FPPC. What sort of violations would you focus on?
Well, we had a time when those people were fighting. I think our tax measure. The
Koch brothers.
You had people fighting that. I can't remember. So that and the FPPC went after it was pretty good. So the trouble is, the real substance is hard to achieve. And it's easier just to have a massive regulatory bureaucracy that doesn't really get it at what we're worried about, which is big influencers in secret shaping government in ways that people don't see.
So what do you think the hindrance is there? We need more legislation, or it's got to be a different way that the agencies operate? Or
I think you have to review what do you got. What are the virtues? What are the defects? And you got to think about it. And I think the same thing is true of the education code. We have 12 volumes of the education code. Every year you have more and more laws, and those laws spawn regulations, and those spawn decisions. And So you have lawyers. Lawyers are a big part of education now, and data operators. We have to have data, and data takes expertise, takes computers, takes people who know how to work them. So I think we have to be in a continuing state of review, and if I may use the word reform.
We talk about the $10 lobbyist gift limit, right? And they say, I don't understand why the $10 lobbyist gift limit is still $10. Governor Brown said it was supposed to get me 2 burgers and a Coke.
Yeah, but that was a metaphor in effect.
Right.
What if you made it 100? What if you made it 1,000? You could do that. It's another one of these limits. The reason I put that in is because I noticed the lobbyists were buying dinners for all the legislators. It was rampant. Now, how bad was that? It's an influence, but the curbing of lobbyists does nothing to curb their employers, their bosses who buy dinner all the time. So, you know, that was a measure, but it, you know, it was pretty limited.
So is there a way that you think to crack down on that beyond just transparency?
Well, what I saw, walking into restaurants, I'd have dinner with an assemblyman, and all of a sudden the lobbyist would leave his card there, and he picked up the check. So I thought that had gotten out of hand, and I thought we ought to stop that. So that was the purpose.
Okay.
So I'm surprised that nobody's wanting to increase it. Maybe the lobbyists don't want to increase it, because they just get their employer. So that's the trouble with all this. You have money and you have the power of government, and the two are going to be interacting all the time.
Yeah, I worked with an attorney who said money in politics is like a bubble on a carpet. If you step on it, it's just going to pop up in another place in the carpet. Somebody's going to get creative and find a new way.
Well, we're in a capitalist society. Money talks.
And I think the words to live by, better is better. And with that, our second panel is about the present situation with the Act, and our moderator for this panel is Professor Mary Beth Moylan from McGeorge.
Thank you. Thank you. Well, we have a great panel, and I'm sure we're going to resolve Governor Brown's Goldilocks problem right here. We'll find the sweet spot of what we should be doing, what's being done. Our overarching question is to ask how the Political Reform Act and its commission are currently fulfilling the intentions of the legislation and what we can do to improve the act or the mechanisms for enforcing it. And joining me to look at this question, I have Karen Getman, who's immediately to my right. She's the founding partner of Olson, or one of the founding partners of Olson Remshow, one of the state's leading political and governmental law firms. She was the first woman, we've already heard compliments to her on her time as chair of the California Political Practices Commission. She has a robust political law practice with an emphasis on legislative analysis, initiative drafting and qualification, and advice on conflicts and lobbying laws. She's been named to Capital Weekly's Top 100 list for the past 3 years, most recently for her role in securing full Proposition 98 funding for schools despite the state's budget crisis. Ms. Getman obtained her JD from Harvard Law and her undergraduate degree with distinction from Yale University, and she's an active member of the California Bar. To her right is Nikki Lorenzo, an Emmy Award-winning television anchor and political journalist at Fox 40 in Sacramento. She is co-host of Inside California Politics, Next Star Media's weekly statewide political show. Before joining Next Star Media Group in California, Nikki worked as an anchor and political journalist in both Texas and Montana. She has interviewed numerous California and U.S. political figures and was the moderator for a 2024 U.S. Senate primary debate in California. She's a graduate of the Edward R. Murrow College of Communication at Washington State University. We're glad to have her here. Jenny Skelton is to her right, and Jenny is a partner and co-founder of Politicom Law, LLP. Ms. Skelton specializes in, there's a lot, federal, state, and local lobby, campaign, pay-to-play, gift, revolving door, and ethics laws and compliance, as well as enforcement actions before federal, state, and local ethics agencies. From 2002 to 2004, Ms. Skelton served as counsel in the FPPC's Enforcement Division. And significantly for our venue, Jenny is she's what we call a triple tiger, actually, and that is a unique state of being. She graduated with her JD and her LLM from McGeorge in our governmental affairs programs. And she also received her BA in political science and pre-law from University of the Pacific. So yeah, that's 3 different degrees, all from Pacific. That's triple tiger. Okay. So she is a member of the bars of California, New York, Oregon, and Washington State. So well done, Jenny. Okay, we're going to jump in. And we're going to categorize, we're going to take 3 categories of topics and tied to the important functions that the Political Reform Act hope to regulate: education, advice, and enforcement. And we are hoping to leave plenty of time for questions. We'll see if that happens. And I've asked that a microphone be brought around to people who have questions when we get there. So if you have a question, wait for the mic, please. Okay, starting with education. Karen, can you speak generally to the purposes of the Political Reform Act with respect to educating candidates and advocates, and give us a sense of how you think it's going as we've hit this 50-year mark?
Sure. Hi, Carol. Nice to see you. To prepare for this, I went back and I looked at the ballot pamphlet for the Political Reform Act, which actually Nikki has up here as well. And I hadn't read the findings and purposes in a long time. And I was kind of surprised to see that among the findings and purposes, there was not one word given to educating public officials. It was about controlling the behavior of public officials, and it was about some transparency, the ballot pamphlet. I don't think a lot of people realize how important ballot pamphlet reform was in the Political Reform Act initially. But there wasn't any thought given to how you were going to educate there was thought about giving the public information about campaign finance and lobbying and things like that, but not a lot about how you're going to actually comply with this law, which back then was complicated even at the beginning. And I think the good news is that the original FPPC had some extraordinary people who did things like set up telephone lines where people could call, and this was extraordinary for a public agency at the time, and I think it is even more extraordinary today, where you could call, ask a question, somebody would actually answer the phone in person, and even more importantly, answer the question. I don't know if you ever tried to call the IRS. I mean, it is extraordinary public service. And I don't think the agency gets enough credit for that. You can write to them, and you can actually get an answer. And now they've made that kind of quicker because you can write an email on a simple question and get an answer. And so that is an extraordinary thing that the Commission does, that it's just unparalleled among other agencies in California and really at any level of government. But why do they have to do that? Because this is a really hard law to comply with. And as somebody who's sort of been on both sides of it, you know, we represent people all the time who have no idea that they violated the law. They don't really understand the law. And as much as the Commission has put information out there, even helping them figure out where the information is sometimes complicated. So there's this continual tension between how much information you give, how you provide it, how they find it, and what they do with it. So I think the agency is doing an extraordinary job, particularly now. They have videos on the website. There's always been a real effort to have people go out into the community and actually engage in person, help people in person figure out how to answer, how to fill out a form, what they're supposed to be doing, and that's really great. I commend the agency for doing that. If anything, that should be one of the most important functions. But it's not just the people who have to comply, which, by the way, are literally hundreds of thousands of Californians have to comply with this act, right? And so that's one thing to take. When you look at how many people have to file Form 700 Statement of Economic Interest, the last time I actually looked at it, it was literally hundreds of thousands of people. So you can't possibly reach them all individually. So putting that information out there is critical. Being able to answer the questions are critical, but there's also another component of it, and that is educating others who are interacting. So I'm so glad that so many members of the press are here, because it's hard as a practitioner. You'll get a question about, did this violate the law? Somebody's saying this to us. Should we investigate this? Is this something? And as a practitioner, I can't always answer those questions because I may have a client that's impacted, but I do hope that the agency will start giving greater thought to how they are helping educate the press as well, because if you guys don't understand it and it's not being communicated to the public, that's a problem. But I do want to say that I don't think there's another agency out there that does more to try to educate people than the FPPC, and they should get a lot of credit for that. I don't think there is a more important thing that you do, because what difference does it make if we have these disclosure laws if nobody knows how to do them, and also nobody knows what they mean or what they're supposed to be looking at? The downside, one of the downsides, of course, with this complicated law, I think you heard people mention the California Political Attorneys Association. When Lance and Chuck first started that, you could fit in a conference room, right? And you could have lunch together. There's almost 200 members now. Now, California's a big state, but it takes almost 200 lawyers out there to develop that kind of expertise to help people comply with the law. So it has now become this enormous bureaucracy, in a sense, and that's, I think, a real challenge for the commission going forward.
Thank you. Nikki, as our representative from the press, can you pick up on what Karen was mentioning and talk a little bit about what you perceive to be the resources that the FPPC is providing to the press for education, and maybe what resources might be helpful?
For sure. And I just want to say I'm grateful to be on this panel, not only to be with two very brilliant women, lawyers, I might say, the journalists sandwiched in between them, but I got to geek out on this voters pamphlet and also read the rebuttal argument on it. And there was two things that struck me that I found pretty interesting. The rebuttal was by a state senator out of San Jose, Clark Bradley, who said, maybe these problems of corruption happen on the East Coast, but we don't need these out here on the West Coast. And another part was powerful interests do not dominate elected officials in California. So obviously history did not support that argument. But I'll also kind of point to the panel that was prior to us was, look, I don't have to sit here in front of you guys and tell you, the press has shrunk on the print side and on the television side. And there's also this theme that the trust in media isn't there anymore. There's things that are very similar. When this act was passed, there wasn't trust in institutions. That is alive and well today. And there's also not trust in the press. But where there is trust, there was a Pew Research study earlier this year that shows that the public trusts local media because they feel like we drive the roads, we shop at the grocery stores, we experience the life, the lived experience that they have. So when there is trust, they have it in us. With shrinking resources, that really puts more of a burden on us in a way that we have to wear many hats. So, and that also means we have a lot of younger reporters coming through newsrooms, and getting them educated is sometimes a challenge. And if you were to do a survey of my industry across the state, they might not even know the FPPC exists. And I'm not saying that that's a dig at the FPPC. It's just, there's so much happening. We're in this quick landscape and newsrooms are just shrinking. And I'm gonna give a shout out to Jay because he does a great job getting press releases to us. If there's something big, really trying to get that information in front of us. I would say if there could, more education for us as an industry would always be helpful. Yes, we can go and watch the videos and we can follow on social media, but sometimes we need it, hit over the head a little bit sometimes. And seminars, just really sort of, even if it's a workshop, just showing the importance of something like this, because we are a shrinking industry, and I'm not trying to be accusatory here, but the politicians know we're a shrinking industry, and they know that they can get away with a lot more now than they used to be able to, because there's just not the attention that there used to be. I mean, City Hall, we don't have, like my station alone does not have a reporter assigned to City Hall. When I first got started in journalism almost 20 years ago, that was my beat. I covered City Hall, and that was all I covered. And that was in a small town. And so the more outreach, the better, and giving us the tools so we can sell it to our news director. This is why we need this information, so we can tell our viewers that there is this agency out there that's holding government officials accountable, and there are these guardrails in place, because that's information the public wants, because they truly think, and surveys show, that we're not doing enough. So the more information we can have, the more we can interface. We're always into something like that, and I'm always going to be a proponent for that. I feel lucky to work for a company that is, committed to covering the subject matter, giving me a statewide platform to, interview elected officials, watchdog groups, veteran journalists like we have here in the front row that you're going to hear from later, in Dan Walters. But the more we can be of service to the public through you guys, the better.
Thanks, Nikki. Jenny, I'm going to turn to you, and we're going to move into the advice category. Karen mentioned what a good job the FPPC generally does about responding and getting advice out there to the regulated community. Can you talk a little bit about the current state of the advice program, and how easy is it to find relevant advice through the advice letters? Let's start with that.
Perfect. As Karen mentioned, we have an abundance of resources for those of us practicing in California in this so-called political law arena, because the FPPC has lots of options available to the regulated community, to the press, to the public who has questions. You can call in or email for informal advice. That advice is issued usually very quickly. Sometimes you'll be able to obtain an answer right away the moment you, for example, if you called in, or you'll get an email back very quickly. But typically, if you have a question that takes a moment to think about, you'll receive a response back from the FPPC in a day or two, which is helpful, obviously, when you're trying to figure something out or answer a question for a client, et cetera. If you have a more complicated question, or maybe an issue that the FPPC needs to think about, you can write in for an advisory opinion. And typically, the way that program works is the FPPC will issue a written opinion, advice letter, to the requester based on your specific facts, and they have 21 days to issue the letter. And sometimes you'll get your letter back in 21 days, but if it's a more complicated issue, they may indicate they need to take a little bit more time. But if you have an issue that you have the time and ability to ask that advice, ask for an advisory opinion when the question, there isn't an answer to it, it's hugely helpful, because you can rely on that advice letter that you receive from the FPPC, and the FPPC couldn't enforce against you relying on that opinion, because they issued that advice to you. You could also get commission opinions if you have other issues. And so all of these resources, and I want to reiterate what Karen said, it's hugely helpful to people impacted by the Political Reform Act, those trying to advise clients on these really complicated issues. And without that, I think people would just be absolutely lost, particularly having such a robust law that's been in effect for 50 years. There's been a lot of laws, a lot of regulations, a lot of changes, and you have to be able to work through and process those changes to the law and really understand where you need to go forward with those particular provisions. The FPPC has on their website a opportunity for users to research advisory opinions. They're posted from 1984 forward. You can search terms and pull up advisory opinions that will hopefully answer your question. The problem with the advice letters being online and the problem with being such an old agency is there's a lot of information that's out there in those advisory opinions, and they're very quickly dated. Obviously, they're drafted at that particular moment in time. That's what the law was in effect, or the regulations in effect at the time that advice letter was issued. And we heard from a prior panel, there's been over 200 amendments to the Political Reform Act. There's regulatory changes all the time. And what happens is people will look at an advice letter and they say, well, this is my answer. Well, that might have been the answer, 4 versions of the Political Reform Act ago and 7 regulations later. And if you are not a true practitioner in this area, you can get very lost very quickly in those advisory opinions. I can't tell you the number of times, and I'm sure others have experienced this, where a client will call me and say, oh, I looked at the advisory opinions and I know this is the answer. And it's like, well, that's great, but no, that's not the answer. It's actually 180 degrees because there's been this law change that's happened, or this regulation is now in effect, or there was a case that changed that advice. So that's a real challenge, and it would be nearly impossible for the FPPC to update all those advisory opinions and note, like, this section is no longer applicable, or there's been a regulatory change that impacts this letter. But if the FPPC ever had the resources and ability to organize or structure those advisory opinions in a way that helped users know which letters were no longer in effect, or which portions of letters may no longer be good law. For those lawyers, the shepherdizing of, if you will, of those advisory opinions would be super helpful. But I understand, obviously, it's a huge undertaking, and realistically, without major funding for a specific project like that, not something that's likely to happen. But to be fair, again, there is a lot of really great information in those advisory opinions that people can look at and utilize to help them answer specific questions.
And maybe even just making sure that there are caveats in place that people do understand that reliance is, I think this is a problem that crosses many agencies, is not having a way to cull and prioritize which advice is still good advice. Anecdotally, last night in my house, because my husband is one of the hundreds of thousands of people who has to fill out Form 700s and just got a new job, and said, good news, I found an advice letter about some little piece of my Form 700, and because we'd been preparing for this panel, I said, uh-oh, are you sure it's still the right advice? And he looked up the underlying regulation and said, still good law. So we knew, but everybody doesn't get to prepare for the panel while their husband's filling out the Form 700. So I do think that this is, you would need many people probably to devote themselves to going through. And again, Jenny, as you point out, it's the benefit of the fact that this has been a 50-year endeavor and that there's been such good communication happening from the commission for so many years that there is this wealth of advice. Turning quickly now to follow up on this a little bit. Karen also mentioned the email advice, and you mentioned the 21 days for the more formal advice that doesn't always happen. In this moment where people are expecting movement so very quickly, can any of you talk maybe about the challenges of having to sometimes wait for that response in what are increasingly short, people's expectations are for a little more speed?
I could start just by touching on it. The FPPC is issuing informal advice every day, and that advice generally isn't available to the public or to the regulated community knowing what that advice is. If there was a way for the FPPC to share that informal advice with the regulated community, it would be immensely helpful to have that additional information. And again, I recognize it'd be a lot of information, but I've seen other jurisdictions have available on, for example, their websites, really brief blurbs on specific issues that have been based upon advice that that agency has given out. And to be able to search that would be more education and hugely helpful, I think, to the public, for example, to public officials who are trying to figure out how to fill out a Form 700, or just anyone who has a specific question.
I agree with that. I mean, the inability to see what's being answered by emails is the flip side of how great it is to get the emails. And there are parts of the practice where people have to move so fast. I mean, I've heard so many city attorneys, they will call us in an absolute panic an hour or two before the meeting saying, oh my gosh, just realized there might be a conflict, trying to figure out if somebody has to recuse or not. And if you're not really well versed in conflict of interest analysis, it's really hard to do that. And city attorneys have a lot of things they need to be well versed in. So I don't know that there's a solution to that, but I think we are in a particular area of law where things move sometimes at lightning speed. And it's great to say that you want more 24-hour reporting and you want more quick things, and you want everything before the election, you want it all up. But at the flip side, you're asking people to comply with a very complex law with almost no time to think about it sometimes. And I think that's something that the agency needs to take into account on the other end of the spectrum. Did somebody have sufficient time and resources to figure this out? And just because the information was out there somewhere on the website doesn't mean that people could find it, digest it, hire a lawyer who knew anything about it, and get to the right answer in a timely manner.
Okay, so turning to when they don't and they violate the act, let's talk about enforcement. And Karen, as we move to that, can you talk a little bit about whether enforcement cases are making their way through the process in a timely and predictable manner?
I think that's another good news, bad news kind of a topic. The good news somebody has made reference to already, the increase in the number of what's called streamlined enforcement matters, where you don't have to go through a huge full analysis and wait. And maybe your client gets sent to what a wonderful thing, I think, is the new PrEP program, I think it's called, where you can get sent to an educational boot camp rather than get a fine. I think is just such an enormous step forward and helpful because it's educating people and you're not wasting a lot of time trying to knock somebody who just clearly did not understand the requirements. So I think that's really great. What I worry about with the increase of that is, the commission gets thousands and thousands and thousands of complaints every year, many, many thousands. And by increasing all of these quicker compliance methods, I hope we don't get to a position where the commission thinks that every single complaint has to be sent somewhere. Because now then you're going to get bogged down. Even a streamlined enforcement matter takes time. And is that really where you want your time spent? So I do hope that there is still an emphasis on prosecutorial discretion. There is not a single prosecuting agency in the country that has enough resources to prosecute every single imaginable violation of the law, which is why sometimes you run a red light and the cop pulls you over and yells at you a little bit and sends you on your way. So I don't know how you balance it. That's always a tough balance for the agency. But you can't then sort of say the 300,000 people who file Form 700s, no matter what happens, will always be sent into a streamlined program, because then you're going to get bogged down in your streamlined programs. And there are big cases, I think Ann mentioned one, where you do need to spend the time, the laundering, the really difficult conflict of interest areas, and you need to free up the enforcement division's time to focus on those. So it is an ongoing balancing question. You don't want to let too many little deadline things pass without enforcing them, because then you make people feel like deadlines don't matter. But if you spend too much time enforcing little deadline things, then you are tying people's time up. And I know you're making progress on the backlog. I'm going to let Jenny talk about that a little bit. I can't tell you how frustrating it is, both as practitioners and to our clients, to have somebody where complaints filed and there's one enforcement attorney or investigator that you work with for maybe a year, and then there's radio silence for a year, then there's a new team that comes in and you kind of get everybody up to speed, and then there's radio silence for a year, and then you suddenly get from somebody else a draft stipulation and a note that says you have 7 days. And if you don't say yes or no in 7 days, we're going to file a probable cause, because we've actually let the time limits run, and now there's the statute of limitations problem, and now that's going to be your problem, and you have a couple of days to respond to this. I mean, that's not fair on the other end, and I understand why it happens, but I think that is an enormous problem for the agency, and one where, again, you've got prosecutorial discretion. Did you need, if that's something where in 4 years you didn't manage to bring it to fruition, do you really need to bring it to fruition now? Sometimes maybe yes, but cleaning up a backlog doesn't necessarily mean every single case has to get all the way to the finish line at the expense of some of your other priorities.
Jenny, you want to follow up on that?
Sure. As someone who practices in the enforcement arena, and having been on both sides, I know how many complaints are filed, and I know how long it takes to do a thorough investigation and bring an enforcement matter to conclusion, particularly when there is a stipulated settlement. The frustrating part, echoing Karen's comments for those in the regulated community, is when I have a client or a potential client contact me saying, I didn't know I violated the Political Reform Act, can you please help me through this enforcement action? And you're advising them, they're like, well, when's this going to be resolved? I don't know. Could be 5 years. What do you mean it's going to be 5 years? And it's like, it depends on the statute of limitations in this particular matter, staffing at the agency, funding, what their backlog is. And I don't know what the caseload is at the FPPC. I'm not there. I know there's a lot of cases just from ones that I have pending. But to tell somebody who's genuinely concerned that they have broken the law, and usually they didn't know that they broke it, and tell them that you have no idea when there will be any conclusion to their matter, is really hard for them to stomach, and it's hard to advise clients on those issues. Echoing and mirroring Karen, anything that the agency can do to clean up that backlog, I know it seems, at least to me, that it is pretty backlogged at the moment, because I'm not hearing from the agency on cases until the statute of limitations is just about to expire or has expired, where there's a request for a tolling agreement, so that the agency has time to then properly investigate that case. Again, these are things that were alleged many, many years ago. Is that a best use of the agency's time? And that's something for the FPPC to consider as the agency's moving forward. Do you have the resources to be able to address that backlog? If not, what steps can be taken to put the agency in a position where you're able to timely move enforcement actions through the process? And I think that the streamlined programs are helping and provide outlets to be able to move cases that need to be prosecuted in whatever manner through that process. But the bigger cases or the more complicated ones, I think that there really needs to be time and effort spent on figuring out how to ensure that those issues are timely addressed.
Thank you, Jenny. Nikki, turning to you, when the FPPC is getting through enforcement actions and is imposing penalties or fines, how easy is it for the media to become aware that those things are going on and to communicate those decisions to the public?
So it depends on a few things. It depends on if there's, it was a big enough story that was in the news that we've been following for a while. We know the complaint's there, and we're going to be continually following up on it. If it's something that we might not have been following, that the FPPC is going to send out a press release, and it's going to be sent to an email address to our newsroom. We get thousands and thousands of emails a day, and our assignment desk manager might miss that one. But if there's, a name that we've been following, that's something pretty quickly that we would notice and we would update. Also, the famous line in local news, if it bleeds, it leads. It is what it is. The higher the fine, the more salacious the story, the more apt we are to be on that right away, put up a web story, get the copy on TV, and put it out on social. I have been told when I've pitched things before, it's like, is a fine of this, is that really that big of a deal? Do people care? But I'm like, you have an agency that's regulating this. Yes, they should care about every single dollar. So that's a little bit of a fight that I have, in my newsroom, that I know that happens in especially broadcast newsrooms across the state, and I would say across the country too, for that matter, with my experience working in other states. But the bigger the storyline, the bigger the headline, that will drive how quickly we get it out.
When we were preparing for this panel, Nikki, one of the observations that you made was that while you have tried as a reporter to sort of follow the lobbying piece and to try to identify when lobbying laws are being violated, it doesn't seem that the lobbying laws are being particularly robustly enforced by the FPPC. Can you talk a little bit about that?
Well, I thought it was interesting too when Governor Brown was talking about the $10 cap. I mean, I do think we need to adjust for inflation a little bit, because I know, can we go to Temple Coffee and get 2 coffees for $10? I really don't think that we can. And look, the famous line by Speaker Unruh, "Money is the mother milk of politics," that's never going to go away. And while it might not be, the blatant ways that we've seen in years past, especially when there was the FBI investigation at the Capitol, and we've seen, instances in LA City Council cases, the influence is there, and you're just seeing it through outside groups. And this is my observation of covering, especially the state capitol. You will have lawmakers that we have interviewed when there will be, a controversial bill up, and you ask them a question about the bill, and they can't tell you what's in it. And so, in a couple of instances this legislative session, and the more digging that we do, we find the interest groups, and not to completely pick on organized labor, but we saw that this session, quite a bit, where a lawmaker specifically asked about, a legislation, and they can't tell you, and the follow-up is, well, you wrote the bill, and then there's silence. So while the sausage being made process might not be, there was a lobbyist A, there was money being exchanged that way, but there's influence there by outside larger groups. So that, and obviously this is a gray area. You have special interests, and that's always going to play a role in politics, but that's something that I know that myself and other reporters have found to be pretty striking, over the past several years that I've covered the legislature. And we also can, link that to term limits, which I know is a whole other panel discussion.
Yeah, I think we probably don't have time for term limits, but it would be fun. Jenny and Karen, your observations about the enforcement of lobbying laws, how the lobbying laws of the Political Reform Act are doing. Is there attention we need to be paying so that we can address some of the concerns that Nikki's raising?
So let me start. I'll do the electronic. So I was chaired 25 years ago now. And at that time, California was in the forefront of electronic filing of all kinds of things. We were one of the only agencies that had kind of close to real-time reporting on campaign finance, but never on lobbying. And I can see Linda back there and Trish, right, laughing, because we had a task force back then with the Secretary of State's office to say, we've got to modernize the online filing system, both because it was on its last legs 25 years ago, and because the lobbying filings were so disjointed, and there was no way to kind of do those matches, and we knew that would make a big difference if you could, easily kind of see, all right, well, who's getting money, where are they getting money from, are those same entities spending on their lobbyists, what are the bills they are lobbying? That should be an easy thing to do. Fast forward 25 years, we have the exact same campaign finance system and lobbying online filing system that we had back then. Linda assures me that it's almost ready, that the rollout of the new one is almost ready, and I really hope that's true because we have heard that a whole bunch of times. So I think until this leading technological state actually gets its act together in updating that technology, it's going to be really difficult to do anything more with some of this. That has just got to be a priority for the state.
Great. Jenny, do you want to say a word? We just got the 5-minute sign, so after you comment, I'm going to invite questions.
Lobbying is, California's lobbying provisions are interesting, particularly compared to other jurisdictions, because there's different thresholds for like an in-house employee of an organization who's engaged in lobbying versus a professional contract lobbyist. And so disclosure, you could have somebody inside, let's say, for example, a corporation who's doing a ton of lobbying, and they wouldn't be required to do any disclosure because they won't have hit the registration trigger, which would be completely different if I was a professional lobbyist, and I had multiple clients engaged in that same activity. I'm likely have triggered and would be filing disclosures in the state based on what the thresholds are. So we can have discrepancies in reporting just based on whether or not someone hit the registration threshold. And I know from practicing in this area for 25 years, I talk to people all the time who they'll tell me what they're doing, and they're like, well, I'm not lobbying. I'm like, you were absolutely lobbying. You need to register as a lobbyist. Well, I'm not a lobbyist, so I'm not registering. And how's the FPPC supposed to enforce that? That's a difficult enforcement matter for the agency to become aware of unless someone were to file a complaint. So I think that, back to Mary Beth's question, that's one of the reasons you don't see a whole lot of lobby enforcement cases, because they're difficult to find unless a complaint is filed.
Yeah. Okay, great, thanks. Questions or statements, if you wish, retorts are also welcome. Yeah, and do we have the mic somewhere? Okay. It's coming down to you. Right down here.
About the enforcement docket at the FPPC and every other ethics group in the state and maybe country, when I worked in a public defender's office, it was just understood the docket was huge, beyond what any human can handle. When I worked at the Court of Appeals, we called ourselves the busiest Court of Appeals in the state. This was in Oregon, and I know every Court of Appeals says that about themselves. But there seems to be this appreciation of that. The public seems to mainly understand. With ethics enforcement, I don't feel like that's there. I feel that there's this pressure and no understanding of prosecutorial discretion, as you were talking about, or just a huge docket. And I don't know why that's missing, but I'm wondering what you think about it.
What do you think?
Why it's missing?
Yeah, what, I mean, do you think?
Do I think the public is?
Yeah, do the public have a different perspective of ethics agencies and what they have to do in enforcement?
I mean, that's any sort of layer there can be out there where the public feels like their elected official is being held accountable. I think that's a favorable aspect. Am I answering your question correctly? Okay, yeah. I mean, I think in feedback that we get, in surveys that we do, in research that we do, the number one thing, we actually just did a large focus group of about 600 people, which is large for TV, in terms of what they want from us and as a local television station. And holding elected officials accountable and detailed reporting on it was number one, which is great job security for me, which I loved. So I think sometimes, we get into the idea that this is a little too nuanced for the public and for the viewer, and they're not going to understand it, and they're not going to want to get in the weeds with it. And that's something I think that we need to kind of refocus in a way, because there is a hunger for that information, and we've somewhere along the line made that perception, and it might not be that accurate. Did I answer you?
Yeah, I mean, I think a lot of cities are moving toward dashboards.
Yeah.
The public can see about where things are.
And that's our job, is to show them the dashboard. Is that, because I think we need to spell it out better.
Yeah, well, I think we can maybe sum this up, and I know we are actually at time, but I do think that appreciation for the workload that the FPPC is doing, and maybe all of us as ambassadors for what good work it's doing, what some of its challenges are, the fact that it needs more resources. I think it's more publicly known that courts and public defenders' offices are overworked, and we maybe all haven't done a great job of letting the public know that the FPPC is doing great work but needs more support in the work that it's doing. So how about if we end there?
Perfect.
Okay, thank you.
Thank you, Mary Beth, Karen, Nikki, and Jenny. I can't speak for enforcement or legal, but I am planning a media webinar with the ILG, CBA, and hopefully Newspapers Association before the election. We will now take a 10-minute break, so enjoy some of the refreshments that are there. We will be back in 10 minutes and begin our next panel at 11 a.m. sharp. Thank you. All right, well, I guess less than a minute then. We'll continue on. Welcome back. As we continue our program, we will next hear from Governor Brown as he opines on the future of the Political Reform Act and political reform efforts in general.
Let's move on to the future of the Political Reform Act. So rightfully so, there's a lot of people out there who are concerned about the impact of emerging technology like generative AI, right, like ChatGPT. I'm also very excited about the promise of generative AI in terms of bolstering transparency and assisting us in our enforcement efforts, right, identifying potential conflicts of interest, for example. Do I understand you've used ChatGPT? You were talking about how it made an impression of a leaf. I watched another interview you were doing.
Oh yeah, well I I checked it out. I was using it. Yeah, I had a lot of questions yesterday. Yeah, it's very amazing what you can generate. So I don't know. Figuring out how to apply it, you're going to have to do that. But you could collect a lot. First of all, you require so much data that you can't process it, and a lot of that data is highly burdensome. And then you have to ask, what are we getting for that? And part of the solution may be the advanced computerization that you can collect all this data. You might also see patterns that that might help in your enforcement efforts. But I think it takes a lot of insight and wisdom to know how much government you want to push, and then how much you want to just leave to the competitive marketplace.
That's a really good point. I think one of the main concerns people have are deepfakes. So for example, there was a video put out pretty recently that upon first glance, you would think it was actually Vice President Harris speaking, but it was actually an AI-created fake. There's been various different other advertisements, fake advertisements, misleading advertisements. And for me, I think transparency is key, because it's going to be really difficult to stop anybody from doing that, right? Similar to what you said earlier in terms of someone's always going to break the law. So it seems like transparency is the answer.
Well, you got to get it, but you have to have it tie into the California reporting laws.
Right.
So if somebody made that video, it's not in a campaign. Well, it's a campaign now, I guess.
Right.
So you say that's a campaign contribution. You have to define it.
It's true.
So I know, I wrote the definition of a contribution. It's expenditure furthering an election. I think something like that. So is this furthering an election, or that's a good question. So I mean, do you think you could regulate that?
I think it'd be difficult. I think an easier way to do it would be to require disclaimers. But then the problem is, how do you know whether something is created by a computer, created by artificial intelligence or not?
I can tell you, because I've done many robocalls, the disclaimers are rather long. And so you get 30 seconds, and 5 or 6 seconds got to go to the disclaimer, which is kind of crazy, in my opinion. The problem is bureaucracy grows in response to complexity. And how you handle that takes, I think, a lot of clarity. You have to keep your mind open, keep your eyes open. So, yeah, if we're going to generate a lot of false images, that's definitely a problem, and the FPPC could perhaps contribute to the solutions.
And if you were in my position, would you approach it? Would you get everybody in a room? Would you get the tech folks in the room, get Common Cause in the room, get the FPPC folks and have them?
Look, the key question that I learned at Yale Law School, the key question you always have to ask, do we have a problem? Do we have a problem? Then, and what is that problem? So you got to get people in the room, figure out what's the problem that you're going to solve for. Muddle-headedness is rampant, and the remedy is clarity. That's the most important thing. If you ask me, what's the threat? Muddle. What's the answer? Clarity. And it's relentless. You have to keep cross-examining yourself to make sure what you're doing makes sense.
So another ethics type question, not necessarily related to the act, but the U.S. Supreme Court. So the U.S. Supreme Court's been under a magnifying glass lately in terms of its ethics, potential conflicts of interest. Do you feel like an ethics code would be helpful? If you
I'm not sure.
The Constitution?
Well, I'm reluctant to see more laws, except when it comes to climate change, where I think we need a lot of laws. So that's a little inconsistent. But ethics code, if it's possible, I'd like to look at what these Supreme Court judges have done over the last 100 years, and look at their behavior, and do we need a code? You know, you had that Abe Fortas, and he had some legal relationship, and then he had to get off. So there is a code. There's limits. Now, do we want a Form 700 for the Supreme Court judges? I wouldn't wish that on them. I think the idea makes sense, but how do you implement it? And then you have the separation of powers. Maybe that's an issue. I'd like to hear what Brian has to say. I think it's certainly an important question. I mean, the idea that these rich people, oil industry, labor unions, whatever, can wine and dine the court, that certainly undermines public trust, but also distorts opinions. Mm-hmm. You know, I mean, what's his name? Some of those guys go hunting. You know, it's nice to go to these clubs. So I don't know. When my father was governor, he got a free membership in the Jonathan Club and the Balboa Club. He got free passes to the movies. I thought that was nice. How bad is it? I think you really got to think it through. What do you get? What do you lose? There should be some kind of code there that the Supreme Court follows, and you probably ought to invite them to come up with something. And if you had any normal civilized world, you'd have the president talk to the Chief Justice and work something out, because they'd want something. So they should, yeah, I think there's a way to get it done and do it well. You're trying to regulate a rapid stream of money and influence, and you have limited tools to do that.
Muddle-headedness is rampant, and the remedy is clarity. There's some more words of wisdom. Our third panel looks at whether the Act can keep up with the changing practices and the technology, and our moderator for this panel is our own chair of the FPPC, Adam E. Silver.
Well, thank you, everybody, and welcome to our third panel on AI ethics and elections. Can the Political Reform Act keep up? And I quickly want to thank the governor again for his candor and for adding to my vocabulary with muddle-headedness and dilly-dallyer, another word you didn't get to hear from the interview today, that he enjoyed using during that interview. But as to our panel today, so I'm very excited about it. We have an excellent group of panelists. And we're talking about a timely issue. We're talking about artificial intelligence and its impact on elections and ethics, right? And many people have said that this is going to be our first ever AI election. So again, very happy to have these panelists here to discuss those issues. We're going to start with Assemblymember Gail Pellerin, who represents Assembly District 28, one of my favorite places in the world, Santa Cruz. It's also the home of the banana slug, and there's been an important update related to the banana slug that I'll let the Assembly member note for you all.
There we go. Yes, well, our banana slug bill, AB 1850, will declare the banana slug our official state slug. Wow. And we're hoping it gets slimed into law very soon.
And when Ms. Pellerin's not advocating on behalf of the banana slug, she finds time to be the chair of the Assembly Elections Committee as well. And prior to that, she was county registrar for Santa Cruz County. So very much looking forward to her insights on this topic. Next, we have Drew Liebert. Drew's one of the longest serving senior staff members of the California State Legislature. Most recently, he was chief of staff to Senate Majority Leader Bob Hertzberg. He's served nearly 2 decades as chief counsel of the Assembly Judiciary Committee, advising on California's civil justice system, voting rights, and democracy issues. He's a Phi Beta Kappa graduate of UC Berkeley. He also holds a master's in public policy from Claremont Graduate School and a law degree from UC Berkeley. Drew has been named a California Lawyer of the Year, lectures frequently on legislative processes, and serves on the California Privacy Protection Agency Board. And also, and this is something I believe is going to come up during our discussion today, he directs Cited, a nonprofit focused on election protection, and he sits on the board of California Common Cause. Hopefully we're not making my newborn baby too upset with all these topics. His name is Alden, and he's thrilled that you're all here to join him in celebrating the Political Reform Act. Excellent. And next we have our last panelist, but not least, and that's Scott Morris. Scott is a senior strategic client executive at Microsoft. He has over 30 years of experience assisting government agencies with acquiring and implementing IT projects and other government tech projects. He's joining us today as part of Microsoft's Democracy Initiative, and that initiative provides their cutting-edge technology to elections-related groups across the globe to ensure integrity in elections. So with that, I thought it'd be helpful for the group to touch on a couple terms that are going to come up during today's discussion. So we're going to talk a lot about generative AI. What's that? That's going to be any sort of artificial intelligence, machine learning that generates content, right? So generates text, generates video, generates audio, that sort of thing. And one of those types of content that we're going to be focused on are deepfakes. And deepfakes have a lot of different definitions depending on who's talking about it. I'd say it's going to be content that is generated to deceive the audience as to a specific fact, right? And there's a lot of examples of deepfakes in the election context and outside of it. For those of you who trade stocks, you're probably familiar with the deepfake of the Pentagon building that showed the Pentagon on fire. That photo was posted on Twitter, and immediately the stock market went down by hundreds of points, with everybody assuming that there was an attack on home soil. Obviously, that was fake, and subsequently, prices went back to normal. However, I'm sure somebody did quite well that day who knew that was going to be posted. Another example we have right here is a more recent example of a deep fake, and this came from the Maine primary, Maine state primary last year.
What a bunch of malarkey. We know the value of voting Democratic when our votes count. It's important that you save your vote for the November election.
So that sure sounds like President Joe Biden, but that's in fact not President Joe Biden, and that was created with generative AI. And subsequently, the creator and distributor of that was fined $1 million for, or I should say, by the FCC for doing this, for attempting to deceive voters in, and as the Assemblymember pointed out, New Hampshire, not Maine, right, about the election that was coming up, that primary election. So as you can imagine, after hearing that, if you hadn't heard it before, the technology right now, which is evolving by the day, has the ability to be this persuasive and impactful. So it really concerns me. I'm sure it concerns the panelists. I'm sure it concerns all of you, how this is going to be weaponized in upcoming elections. But also, I want to focus on the positive in regards to AI. We're going to be touching on how this amazing technology, machine learning, computing power, can be used to further the Political Reform Act's purpose, right? So to promote transparency, to bolster the enforcement of our laws, and then to better educate public officials and candidates, all of which are priorities for me as chair of the FPPC. So why don't we start with that point, because we already started talking about the scary stuff. So how can we, and this is a question for the panel generally, how can we best leverage this technology to further the purposes of the Act? So I know, Scott, I know Microsoft's working on these types of issues.
Yeah, why don't I start out? Thank you for the opportunity to be here. First of all, very grateful to be a Californian and helping to make our state, the best place to be on the planet for everyone here in California. So this truly is an exciting time to be alive. Earlier this year at the World Economic Forum, Zanny Mitten-Beddos, who's the editor-in-chief of The Economist magazine, referred to generative AI as the steam engine of the fourth industrial revolution. And I've been getting up to speed on what those four are. Robotization is the fourth industrial revolution, and the third, when I started my career, is automation. So when I started my career back in '93, essentially, I didn't even have an email address. And so we were just in that dawn of getting access to technology and automation. And why is Gen AI such a big deal? Well, from my perspective, it's really democratized access to advanced computing and data science capabilities for the layperson, not someone that doesn't know how to program. And the two key elements of the technology are, first, the natural language interface, which is available today in many, many of the world's languages, and then the human-like reasoning engine that's been trained on the world's publicly available information. And my day-to-day work life has changed because of access to this new powerful tool. I can't imagine someone trying to keep up with their colleagues next door that are competing with them without taking advantage of these technologies that come with risks that we'll talk about. So how is it impacting business and government today? AI is helping to increase employee productivity, engagement, and well-being, removing a lot of the drudgery and mundane tasks that we deal with day to day. For example, in government agencies, helping to accelerate the onboarding journey. Earlier, we heard about how difficult the laws and regulations are to understand. Creating chatbots or conversational assistants that you can ask questions and get very high accuracy type responses without having to dig through a bunch of documents is a good example. Reinventing the customer experience. All of us working with the DMV or interacting with the government. We need better ways to get access to the information and services that we want. It's also reshaping the way businesses or our governments are running their organization, and then accelerating the ability to innovate. And we can talk about some of the use cases that Adam, you and I have talked about for FPPC, but I'll stop there and let others weigh in.
Sure. And just to piggyback on what Scott mentioned there, I think what's really amazing is not only that these chatbots can answer your question, right, but they can also provide you with a citation to where the information came in that response, right? Because we've seen with some jurisdictions, some private entities who have launched AI-related chatbots early on, that there's some inaccuracies, hallucinations as they're referred to, that mislead the public, right? But AI has evolved just in a short amount of time where it can provide that sort of context and that sort of reliability, that it can be an excellent tool, for example, to provide very basic ethics advice. You know, what is the gift limit? A AI-powered chatbot could then identify what the gift limit is and provide you with a citation to where the recipient of that response could confirm that fact. Any other thoughts from the panel on how generative AI and these technologies can be used?
Sure. Happy to step in there. And I also just want to give a shout out to some former Assembly members here, Ken Cooley and Catherine Baker, who's now a commissioner, and my colleague now, Senator Steve Glazier, has come in, so good to see you, former chair of the Senate Elections Committee, and so lots of expertise here in this room. It's my honor to be here today. And yeah, I think that, you know, I spent 27 and a half years working as a chief elections official in Santa Cruz County, and we were inundated with phone calls about the Political Reform Act. Well, what do I do about this? Or I'm doing this kind of fundraiser. How do I report this or that? And I got very used to saying, I am not an attorney, and I cannot give you legal advice. However, and I'd go get my manual, and I'd say on page, 57, section, that it states the following paragraph, and I would read that paragraph to them. And today the manuals, I think there's one that's 320 pages, and for somebody running for the first time for elective office, it's daunting. It's really complicated, all the election laws, and then the Political Reform Act on top of that. And so I think having an ability to take all that information and have it available online, and I know that people do call the FPPC for advice, or they'll do the advice letters, but having that search tool to be able to ask their questions directly into an AI system that then could do what I did, tell you what page and what manual, and then read it to them so they can understand where to find that citation would be really super helpful. So I think that would be a great use of AI. And as stated earlier, the importance of educating people. And in my day, we used to call the Fair Political Practices Commission, and we'd ask them to come to Santa Cruz to do a workshop to go over the Political Reform Act for new candidates, and we'd spend a day doing that. And actually, they loved coming to Santa Cruz. Who doesn't? And so that was an easy ask. And then they moved to the webinar systems where you can get that information there. But education is really key to pointing people to trusted sources, to the right information, so they don't get into a situation where they are having to have an enforcement action against them. So.
Absolutely. And I think it's just important to note that, with the appropriate educational tools, we can encourage people to participate in the political process. It's daunting to run for office. Like the Assembly member mentioned, the campaign manual is over 300 pages long. So that's something the FPPC is focused on doing in terms of artificial intelligence, as well as just bolstering our FAQs, fact sheets, really making it easier for locals and people who want to participate in the political process.
And I even think as a local election officials, there's a lot of tools that they can use. We have a mail ballot sorter that takes those, hundreds of thousands of ballots and puts them through the system where it will capture signatures and sort them into different, we used to sort by precinct, but I had an issue. I'm very slow to come to technology to help us do our jobs, but I still insisted on having human eyes look at all those signatures. There are machines that can actually approve a signature for comparison or not, but I insisted that human beings sit at computers and look at this, which was a daunting task, and I'm not sure they do that way anymore. But I also think that AI can be helpful for a local election official on election security issues. It can be used to monitor cybersecurity threats in real time and detect unusual kinds of activities. I think it'd be a great tool for voter engagement as well, to have those chat bots and virtual assistants that can assist voters by answering questions about where do I go vote, what's the deadline for registration, or what's my voter registration status. And polling place management, I think it could be a really useful tool there to analyze data to optimize voting locations so you don't have so many long lines at certain locations and not at others. I'm really going to be curious to see how AI is going to be used with our redistricting that's going to be coming up very shortly. In just a few years, we'll be conducting our census and reapportioning all our political districts. I think AI can be really interesting in analyzing population data, voting patterns to ensure districts that comply with all the legal requirements. And then just good data analyzing as far as providing local elections officials with voter trends, turnout, demographics, because it's really all about the voter experience. To improve that voter experience, I think that it can provide some great data there as well. So I see some good uses.
Excellent. And Drew, I saw your hand went up.
Absolutely. I am, first of all, wanting to do just a couple of updates. One is that I was an adjunct professor here 8 years at McGeorge, so kudos to McGeorge. Love this school. And the second is I have my nephew here today. Oh, yay. And my nephew is a second-year student here at McGeorge, so the tradition continues. So what I want to say is I am absolutely not going to tell you all the great things about AI. In fact, we're talking about elections here. We just looked at a deep fake, right? A robocall that actually could have absolutely manipulated voters in the state of New Hampshire. In fact, I say beware of the chatbot. You're all reading the same articles I am. And I can tell you that we have chatbots that are telling people right now that they can vote by text. Can't do that in California, can you? Can't. We have chatbots that are sending people to the wrong locations to vote where there is no voting and giving all sorts of false information. Of course, the greatest danger that we face right now is just in the next, 6 weeks or something of our national elections, right? To what extent is there going to be mischief? I'm waiting for that October surprise. It used to be something very physical. These days, I think it's going to be something probably very digital. Microsoft is doing its best, I know, to try to prevent that from happening, but the challenges are enormous. So I think we have to really pay attention to, although AI certainly has great promise, even if you focus on what might happen in the use of AI machines right now with the PRA, there are great challenges. You make mistakes that can affect people's licenses or can affect how much money they have to pay, all of these things. We have to be very careful as we study these enormous learning machines, how they're scooping up all of the information on the internet, all of your information on the internet. I think we have to approach AI with a great deal of caution, and that's kind of what I'm dedicating myself to, is on a policy basis for us to catch our breaths. You know, it was 10 years ago that a guy named Elon Musk warned this country that in the next 5 years, he said 10 years ago, AI is going to create some extraordinarily dangerous situations for this country. And you'll all recall it was just last year that the founders of AI issued an unprecedented warning to the world saying, hey, we have to take a pause here. AI is developing so rapidly, and they didn't even know how rapidly it would be doing this last year, that there are tremendous dangers and threats to our democracies across the world. And so I think we do have to take a pause, and as we think about it for the PRA and all sorts of state agencies, and of course all of us on the internet, we have to be issuing a great deal of caution as we proceed.
And those are great points. And that takes us to our second question here. And beyond deepfakes, what threats are posed by AI in elections? Also, what impact could AI have on the political process negatively? You know, one thing I was thinking about is, you know, we have this phone call with President Biden, right, related to a primary. What if instead of that, you had a voice of a mayor reaching out to everybody in their city saying the election date has changed? What if you have a automated voice that calls a legislative office, creating the fictitious appearance of favor of a specific bill, right? You get thousands of calls from voices that sound real, and you're asking staff to determine what's real, what isn't. Can be particularly problematic. Any other potential threats?
Well, yeah.
You want to take that?
Sure.
I don't want to be totally a downer.
No, well, I'll join you with that because
All right.
'cause I think there's a lot of fear around this as well. We've just begun our, a monumental election year, and we do so with democracy already weakened, trust in our institutions and media at all-time lows, and truth is under assault with the deep voter participation disparities, leaving certain communities out of our electorate. And in this challenging landscape, we're confronting our first AI election where generative AI deepfakes are already flooding our political discourse and leaving voters uncertain about, what's real. Are these images real? Is this audio real? And these videos? And impacting an election by putting out misinformation or disinformation is not new. In the olden days, they might put up a door hanger telling you the wrong location to go vote just to frustrate you and maybe cause you not to vote. But now we have these AI tools that are easily accessible that you can do so much so quickly. And we've seen it already impacting elections in Taiwan, Slovakia. Domestically, we've got the Joe Biden robocall, and everyone recently saw the AI photo of Taylor Swift falsely endorsing Donald Trump. And our beloved childless cat lady has now set the record straight in her Instagram account last night. But she also shared her concerns about AI, that if it's left unregulated and without the necessary guardrails. And so, here's what I think about AI, is it's technology that is changing rapidly. This is the first tool in human history that can make decisions by itself. So remember, open the pod bay door, Hal, for those of you who like sci-fi. This is the first tool in human history that can create new ideas by itself. And while we're learning to use AI, it's also learning to use us. And its potential to disrupt human society is immense, from economics, as Adam explained with the Pentagon photo, to our very democracy. So that is why I am just proud and honored to be partnering with Cited to introduce legislation, AB 2839, which is a bill that that basically says that material that is generated by AI that is materially deceptive is banned 120 days before an election and 60 days after. So we also put in some really good First Amendment protections in there, and also understanding that if somebody's doing a parody or a satire, okay, but you got to label it. You got to label it as such, and that it was created using AI. And so there's other bills in this legislative package. Another one that is by Assemblymember Berman, which is AB 2655. And that one's going to stop the spread of materially deceptive elections communications on social media, and to require that campaign advertisements that contain deepfakes will include a disclaimer if the governor signs Wendy Carrillo's AB 2355. So it's super important that we update our laws and stay ahead of this to address any potential harmful uses that AI could have, and its potential to undermine people's faith in our elections. And this technology is changing so quickly, we just need to continue to be vigilant and be ahead of the game. So that's what we're looking at.
So it sounds like government certainly has a role in regulating this technology. What about the private sector and nonprofits? Drew, Scott, any comments on that?
Well, I hope so, because we're a nonprofit, so we're trying to do it. We have these 2 bills on the governor's desk right now that have to be signed or vetoed by the end of September. So we're going to find out this month where Governor Newsom is. We're hoping that the realities of politics and all the other influences and pressures that he faces, just like Governor Brown did, don't discourage him too much from trying to get California to be a leader. As you know, California led the way across the country when it came to attempting to regulate privacy protection. Many states have now mirrored California's law. It's not a perfect law for sure, but California is now seeking to fill this enormous gap of dysfunction by Congress, right? We know that the federal government is not anytime soon going to deal with these issues regarding AI. We can put out executive directives, et cetera, but Congress is not doing what it needs to do. So California, with people like Assemblymember Pellerin, really are taking leadership roles to try to do this. I can't underscore just how difficult it is to try to engage in policymaking regarding technology. First of all, the tech companies are absolutely the most powerful political forces that I've experienced in the California legislature, besides perhaps the unions and others. And it makes it a very difficult slog to try to engage in really effective legislative work in this area. The lobbyists in California right now are getting paid about $1 million a day if you look at the statistics dealing with a lot of these issues. That's a tough way to go. And then there's the technology itself, which is hard to understand and regulate. And then there are all sorts of confusions about the law. A lot of people think that these companies can't do things because of the First Amendment. But many of you who are lawyers out there know that the First Amendment applies to government entities, not to private entities. So the final thing that I'll share with you is cited my group's perspective and a lot of the nonprofit group's perspective, and that is that these companies that have been given this extraordinary wealth as in this country through democracy have an absolute civic responsibility to do a really important content moderation, to care about the lies and the disinformation that are put on their sites, whether it's what Haitian people are allegedly doing in Springfield, Ohio, or any other of these incredibly malevolent posts that occur. They have a duty to take those down and take them down fast. And government has a responsibility to figure out a way to make sure that they take that responsibility themselves.
So Drew, you mentioned the stagnation at the federal level. How do you view this issue in terms of who should be regulating it? In an ideal world, would you have the federal government be regulating this issue? Would you have state governments regulate it so they could reflect their own values depending on the specific state, both?
For me, there's absolutely no question. This is absolutely on the doorstep of our federal government, right? We need, in fact, this is where nonprofit groups like mine and wonderful companies like Microsoft of Scott's really agree, and that is that there ought to be national approaches to this. It's not fair to Microsoft to have 14 different state laws with different approaches on these issues, but more importantly for the public, there should be some really basic ground rules about what these standards are. And so the federal government should take this up. We've all been watching a dysfunctional federal government for far too long. Let us hope that this upcoming election, regardless of who wins, I won't be political, that we somehow get to a place where the federal government can act. We don't need too many more warnings by those who really understand AI for all of us to understand the importance for there being sufficient guardrails in the use of AI across this world. And so hopefully the federal government will do that. In the meantime, thankfully there are people like Assemblymember Pellerin and the members in this audience who work in the legislature who are trying to do this the best we can as a California leader to kind of set the pace with hopes that other states will follow up.
And then Scott, I know Microsoft's a leader in ethical governance of AI and their products. Can you talk about how you've handled these sorts of issues, parades of horribles?
Sounds like we moved into topic 3, how to make sure that we address these threats, right?
Yes, yes.
So I just wanted to reiterate, my personal commitment as a leader here in Sacramento for Microsoft to use this technology responsibly with all of our state customers. We receive regular, very serious messages from our leadership about the importance of the proper use and responsible use of AI. And we've partnered very closely with CDTA and GovOps, other agencies, to help shape the regulatory framework so that we are only implementing AI that is safe and responsible. So you have our commitment to make sure that these technologies are used for the benefit of Californians, and that we know there are risks. We don't deny those. There are significant risks, but it's going to take all of us working together to manage those risks. But having access to the technology is an amazing benefit as well. So we need to figure out how to manage and control those risks.
And I hope Scott won't mind that I'm sharing the story of how we met and he ended up on this panel. It's pretty amazing. So obviously, AI in elections is something that's very interesting to me. For better or worse, I spend my free time listening to podcasts and watching videos about it. And one of his associates was in a video talking about how government can leverage AI for various different ways, reasons. And I reached out to him on LinkedIn. A day later, he reached back out to me. We grabbed coffee 2 days later. And now Scott's on this panel right here.
I love it.
Right? It's pretty unbelievable what you can do with technology. There obviously are potential pitfalls, especially with AI, but it's amazing. No one would believe that sort of interaction could occur even 20 years ago. And it just goes to show that Microsoft is open and willing to work with governments to regulate and leverage AI, and I really appreciate that personally in terms of the relationship we have with them. Why don't we move on to a question that I had for Drew. So Drew, from your perspective, having worked in the legislature for 2 decades, what are some of the major challenges facing the FPPC in achieving its mission now and in the future?
I loved that video by Jerry Brown, by the way.
Yeah. Thank you.
Do we have a problem? That's a great thing for all of us lawyers, right? We always want to know, do we have a problem? Yes, we have a problem. The first thing I want to say is thank you, Jerry Brown, for having pushed this law in 1974, 50 years ago, and thank all of you who are working to try to make it work. I actually consider this celebration, this 50-year celebration of the Act, a marvelous opportunity for all of us to kind of take stock of how successful the Act is. I think, for example, Dan Walters has probably watched it for about 50 years and has a good sense that it's had a lot of challenges. And so I kind of want to be the emperor has no clothes person for a minute to just speak candidly about my own experience working in the legislature for 20 years, as many members have, et cetera, experiencing the pressures and challenges that massive amounts of campaign contributions place on them as they're trying to do their business. We know that the goals of the Act were extraordinary. I looked back at what they were, and this may remind you, but it's quite breathtaking. The Act sought to ensure government officials serve the needs of all citizens equally without regard to their wealth. It sought to ensure our political leaders perform their duties unaffected by the interests of their financial supporters. It sought to ensure our laws prevent large campaign contributors from enjoying undue influence in the halls of our government. And it sought to ensure lobbyist-arranged campaign contributions no longer prevent incumbents from being effectively challenged. Well, I think if we went through the test and said, well, how are we doing? We'd all say we have a long way to go. And when we look at why that might be, I just want to throw out maybe 4 little quick things for you to think about as we move forward, as we celebrate this Act and the great work that the agency's doing. The first thing, of course, is political will and politician self-interest, right? One of the things this was created in the Act was that it would be up to the politicians themselves to decide how much funding should be given to this agency, right? They were given the responsibility to fund the organization, and that's not fair to them because that's asking the foxes to guard the henhouse. That's not a fair situation. Looking back on it, I think we all recognize that this agency has not been adequately funded from the beginning. The amount of money and malfeasance surrounding our ever more complicated campaign finance system is just breathtaking, right? Back when this act came about, were we worrying about behested payments and so many other things that are done now, cryptocurrency, all of these things that are on the plates now of this agency. It's not fair. The staff has always not been adequately given support and technology that's needed, et cetera. When we get down on the fact that it can take 4 or 5 years for a particular case to go through the FPPC, no one often pays sufficient attention to the fact that they don't actually have a huge staff, and the responsibilities on their plate are just extraordinary. And nor did this act, Jerry Brown, if I was sitting with you and interviewing you, nor did it create the kind of enforcement tools that are obviously critically necessary for appropriate deterrence, right? I mean, the fines that you can do are not adequate. You need much stronger tools in which to scare those who want to engage in malfeasance, and there are many, from not engaging because the risks are too great that they may end up in jail, right? So those are all things that I think we should, at this moment, think about. How can we, all of us here, somehow try to create a greater understanding about the limitations that have been foisted on the PRA and on this agency to do its work, with hopes that somehow it will gain sufficient traction either through the legislature, a tough go to be sure, or the people themselves through the initiative process to revisit this 50 years later. Because it's not a fair fight right now. It's clearly a David and Goliath environment that this agency finds itself in. And I think it should be Goliath.
Yeah.
Agreed. So, panel finished. No. So with that in mind, is there any other changes to the Political Reform Act you would consider, suggest, Drew, Ms. Pellering, Scott?
More funding, right?
Oh, yeah, I would certainly seek to amend the act if I had the power to give much greater enforcement tools where politicians and all those involved in the campaign system could be super nervous that if they don't do things right, and this certainly applies to lobbyists, that there would be really severe penalties that would be faced, right? We have much larger penalties in the old days for having an ounce of marijuana, as opposed to the ability to totally affect the laws that 34 or 35 million people in California face. You know, I thought it was quite telling that in this debate last night, how many of you watched that? Almost everybody, right? Anybody notice if anything was brought up about cronyism and conflicts of interest and the campaign finance system in this country that's broken? None of that, of course, was brought up, and yet it has one of the greatest impacts on what's happening in our lives in terms of the laws that are passed and the policies that we experience. So hopefully we'll be able, as a country soon, to focus a little bit more on this broken campaign finance system.
Another topic I wanted to bring up is Assembly Bill 1170 was just signed by the governor, and that bill is going to require that so-called 87-200 filers, so we're talking high-level public officials, including state and local electeds, they're going to have to file their Form 700s, their financial disclosures, with the FPPC directly via their e-filing platform. So if any of you are lucky enough to have to file a Form 700, as the previous moderator complained about, a lot of people do it on a hard copy Form 700. And then the FPPC or their filing official is going to receive that document, and they're going to have to scan it, input it, a lot of different tasks that have to go on there. Whereas if it's just an electronic filing, it's going to be immediately posted on the campaign website and available to the public. So I thought, since we have a former county registrar, county clerk here, she can speak to just what a significant impact that's going to have.
Oh, yes, absolutely. And, you know, my day, everything was filed in paper. And we actually made an attempt to post it online. So we would have to scan and redact and then post those documents. So, I mean, having the online filing tools, I think, is really critically important. But it was also something that we would have to do, is to give it a cursory sort of look through. Does it comply with everything? Is there anything missing from this document? And that is possibly something where AI could be helpful in scanning through these filing documents to see if there's anything missing or that is a violation, if it's not completely filled out correctly. So they're daunting, they're large forms, and there's a lot that needs to be provided, and we need to have that transparency, and having that ability to have them posted online where then people could search for whatever they're looking for, like did this construction company, donate in this election cycle? I'm thinking about 460s, but I think that there's a lot of potential here by having them easily accessible in an online format that is searchable.
Absolutely. I think that takes us back to that, AI aspect of the conversation. The more of that information that you have online, the easier it is for the public to access it. And with AI, they can access it much more quickly, right? And they could potentially identify conflicts of interest where you have a public official who has an economic interest and they're going to vote on a bill, a permit, that sort of thing that's going to have a financial impact on one of those economic interests. So I'm very excited we were able to get that through. It's been a multi-year effort. We finally got the governor's signature last week. So on that topic, were there any other PRA related ideas that you had, Sylvia Pellerin?
Oh my goodness. I think it's a robust document. I think that we just need to be constantly looking at it. I always tell my kids the only thing permanent in life is change. And I think that holds true for our Political Reform Act, that we need to continue to revise it, make it more stringent, more robust, look at some of those dollar amounts that were capped 50 years ago. Maybe it's time we relook at those. So it is an evolving, changing document, and I think that we need to continue to look at it to find out how we can improve it, how we can make it more stringent, how we can improve transparency, and how we can restore people's faith in our democratic processes.
Excellent.
I have one last thing we could do.
Go ahead.
Right now, in the PRA, it takes a 2/3 vote, if you can believe that, in each house of the legislature, right?
Yeah.
In order to change anything in the PRA. And what does that mean? That means both good and bad. It means it's harder to weaken it, but it's really, really hard to make it stronger. And so one of the things I would do if I were boss for the day on the PRA is I would change that threshold and I'd say, hey, that's not a good thing, right? We have a democratic form of government. The majority party ought to be responsible for whatever they do, and in this regard, they ought to make this PRA stronger. So instead of having this supermajority requirement, you know what I would do, Adam? I would say, let's make it majority, and let's improve this act and give the strength that it needs to have.
It's very interesting. So, Scott, I have a question for you. And as Lance mentioned earlier, so the commission has 5 different commissioners, right? And oftentimes, most of those commissioners are attorneys. I think right now, 4 out of the 5 commissioners are attorneys, if not all 5 of them, right? And there's going to be new commissioners appointed in the next year. And I wanted to get your feedback on what you thought about perhaps bringing in somebody from the tech community or someone from the private sector who could bring that sort of perspective to the commission. I don't think that's something that we've had in the past. I certainly don't have anything against attorneys. I'm one. I'm interested to hear your thoughts.
Well, I'm sure you'll find many attorneys that are tech savvy, but I think this technology is really not, it is a game-changing technology, but it's not any different than any other technological revolution in the past. We have to update our paradigms and models to what's available to us today for tools. And so having someone that understands the power and the risks of the technology is really valuable, I would say.
And it kind of goes back to what Drew said earlier about the federal government regulating this issue. If you look at the Senate, there's just an overwhelming number of senators who aren't familiar with these sorts of topics. So having that sort of background, I think, personally, would be helpful. So we have 1 minute left. Are there any other remarks anybody on the panel wanted to make before we close it up?
I'll just encourage everyone that may have a concern with Microsoft or any of the tech companies out there. Earlier this year, we signed an accord in Munich at the security conference acknowledging the risks of this technology to elections. And we have a an organization called Democracy Forward at Microsoft that is committed to making sure we can have a free and open democratic process. So I'll be happy to field those concerns or opportunities or ideas you have for us to engage, and we want to make this a very happy place for everyone to live here in California.
Hear, hear.
All right. And I also think it's everybody's responsibility to question those robocalls, those ads that you see, those videos, those mail pieces. If it doesn't seem right, check with a trusted messenger, call your local elections official and get the correct information from them, or look on their website. But if we're done, I have a...
Okay, great. Yeah. You have a surprise?
I have a surprise. Yes, yes, yes. So, because it's your 50th anniversary,
Oh, my gosh.
our two chairs of our Assembly Elections Committee, which is me, and then our Senate Elections Committee, which is Catherine Blakespeare, and a shout out to our chief consultants here, Ethan and Scott, somewhere in the room. We would be nothing without your expertise. We have here a resolution from the two of us honoring you on your 50th anniversary of the Political Reform Act. So.
Well, thank you again for that. Let's see. Like I mentioned earlier, I just want to thank staff again. Again, this would not be possible without you, without our current commissioners, former chairs. Thank you so much. I just want to lay out some of my priorities as chair. So they're threefold. I'd say number one, that I want to promote civic engagement, participation in the political process by adopting more fact sheets, by putting more FAQs out there. I want to make it much easier for especially new candidates to comply with these rules. So that's number one. In terms of enforcement, I want to make sure that we're fairly and efficiently handling all the complaints that are coming through, with a special focus on the most serious violations. We're talking about campaign money laundering, conflicts of interest, those types of violations that have the greatest public harm, right? And then lastly, I want to make sure that we're leveraging technology like we've been talking about to further the Political Reform Act's purposes, right? So we want to promote transparency. We want to bolster our enforcement using these sorts of tools. And then lastly, we want to better educate public officials and candidates. And like our previous panel said, we're doing an excellent job of doing that right now. We can always do better. And we're looking at all different types of ways to bolster these three priorities of mine. And if you have any sort of feedback, I have an open door. More than happy to hear any ideas that you may have. And thank you all for coming today. And thank you so much to our panelists for joining us.
We are going to continue now with more of this fascinating conversation with former Governor Jerry Brown as the governor opines on the current state of politics, and that is a perfect segue into our next speaker and our final panel discussion.
Said that we get the government that we deserve. With that in mind, how do you think that reflects on our political process right now that we're in? I know 81% of people say they're concerned about the state of democracy. Is that our fault as citizens? Is it politicians' fault? Is it both?
I don't think you can assign fault like that. Societies are complex social organisms. Like the body is complex. The body has all these systems and cells and organs, all interacting in ways that are still being discovered. There's more unknown than there's known. So when you look at our society, well, you have Mr. Trump, that people on the other side will say, this guy's a liar. He wanted to subvert the election last time. This is pretty bad. But he's got at least 43%, 42% of the people that like it. Now, whether they approve of it all, probably not, but a big number of people. We're not talking 10%. We're talking a lot of people like the Trump approach. which I think, from my point of view, is questionable. Of course, the Trump people look at the progressives and the Democrats, and they see a horror as they experience it. So, does the government? You get the government you deserve. You get the government that can emerge in our particular society. We are, and our society is affected by the global economy, by markets. By the rising inequality, by the different distribution of skill sets. It is what it is. And there's a lot of discontent. When Kennedy was president, in 70% of the people expressed pretty good trust in government. Today, that would be maybe 15 or 20%. So it's dropped off. Democracy, first of all, democracy is not democracy what it was 100 years ago. It constantly changes. So, I don't know the government we get. We have the government we have, and we have the society we have, and we have the climate in the world we have. And it's very perilous, and we just have to think clearly about how we respond. So I don't know where you go with, is it deserve, what is, so the whole question of deserve what, according to the Mosaic Law, according to, Trump, according to Kamala Harris. I mean, we have different values, different perspectives, different movies in our minds. And our reality is there is such polarization. But that's not unusual. They got that in Europe. It's probably because of the immigration, the changing in lifestyles, and the shifting of our reality, of economy, the housing prices. A lot of stuff is difficult, and they got to blame somebody, and it's very natural. But blaming somebody doesn't solve the problem. So we got to figure out ways to do things. And the FPPC has a role in assuring that things are above board and ethical without going crazy. Because I think camaraderie among the politicians is a good thing in government. Of course, if they get so chummy that they forget the people that sent them there, that's bad. But if they're so separate from each other that they can't compromise, then that's bad too. And that's kind of where we are. If you're a Republican, you think one way. If you're a Democrat, you can think many ways, but you don't think like a Republican. So you get very little collaboration. But you can't have a country without consensus.
Before we get to our distinguished panel of journalists, and I guess now former journalists, I'll join the crowd. To introduce our next panel, we are honored to have the senator from California's 7th District, Senator Steve Glazer. The senator has been on numerous committees, including Senate elections and constitutional amendments, and has worked with the FPPC on numerous legislative efforts to improve transparency and accountability in state government. Please welcome Senator Steve Glazer.
Thank you. Thank you, Chair Silver. Thank you, Commissioner Baker, for having me here. It's great to be in this auditorium. I came early because I saw the panel that many of you have heard already today. And there are so many cool veterans that I've had the chance to interact with over the years, certainly Ann and Bob and Charles and Karen and Lance. It's been a great, they've had great service to our state in their professional capacities, and I have been blessed by interacting with them over the years. Certainly this panel is some grizzled, some not so old here today. Seeing Dan Walters here in person, I know, is a surprise to some. Many people felt, I've heard that people thought his columns were all AI generated. It's just spin and repeat, something like that. I know that's not true. Dan was kind enough to come into the Capitol for a podcast I did on Rose Bird, so I knew he was alive and well, and it's great to have him here.
And of course, like an obituary.
I could do that, Dan. No, and of course, John Myers. Many people have seen John and his work over the years, but certainly having him here, it's an opportunity for me to say to John, welcome to the dark side. Not reporting anymore.
Also an obituary.
I could go on, but I won't. So I thought I'd, in the introduction to this panel, make two observations, which I think they asked me to make. One about the PRA, and secondly about journalism. On the issue of the PRA, and it's fun to see my old boss, Jerry Brown, here talking about it, because, and he, I thought, was pretty pragmatic about its success and its shortfalls in the conversations that Chair Silver had with him. Because in many ways, it was 2 steps forward, and then it's been 1 step back. And I know that some of the panelists earlier talked about some of those steps back that they saw, and I agree with some of those observations, and I wanted to share my thoughts as examples in that space, because we know we have decision makers here in the room. But I thought that one of the fun stories that was always told, Bob Stern, I'm sure, chuckled about it earlier, 2 hamburgers and a Coke, that we're really going to restrict lobbyists and their influence. And Jerry Brown talked about where they drop that credit card down to pay for that meal or those drinks or whatever. But I'll tell you, if you go to a fundraiser today in Sacramento for legislators and go watch who goes in the room, who goes into the room for those fundraisers. And it's 95% of them are lobbyists. The people that we thought we were restricting in their ability to influence with money our political process. And so yes, we stopped them from buying more than 2 hamburgers and a Coke, but I could go have dinner with a lobbyist tomorrow, and they don't have to pay for my meal. They'll just give me a check for $5,000. It won't be from them, it'll be from their employer. And that's an incredible workaround when we thought we were doing something to restrict the influence of lobbyists. And if I were to talk about reforms, and I know we had some suggestions that came in earlier, maybe the next reform would be that lobbyists cannot participate in fundraising activities with elected leaders, not have them in the room. You know, we talked about the influence of lobbyists, and we know that. The law was set up that said that every 2 years, 25% of the lobbyists and lobbyist employers were audited to see whether they were disclosing who was giving them the money to influence and where they were spending the money to influence. So we have this crazy idea in the legislative process that we should provide some oversight. So when I was chair of the Senate Elections Committee, we had a hearing to see how the Franchise Tax Board was doing in auditing lobbyists. And what did we find out? That over a 10-year period, in some 2-year cycles, they were supposed to audit 25%, and that would be more than 100. And we found that in some 2-year cycles, they would only audit 3 or 1. In one 2-year cycle, I audited 0. So we have a law that says we're supposed to audit lobbyists and lobbyist employers to see whether they're telling the truth about influence peddling, and our bureaucracy comes up completely with a goose egg that they're not doing it at all. I had a bill to move the responsibilities to the Fair Political Practice Commission from the Franchise Tax Board. It was killed just a few weeks ago in the Assembly. We call it a silent kill. It was done in the Appropriations Committee, and it's even more silent. Why? Because there was never a single story done, nothing ever written about that kill. So it was definitely a silent kill. We know the influence of lobbyists. We try to regulate it, and yet it all goes away in a puff of smoke. And it was said earlier today, and I think Drew mentioned this, that one of the problems with setting up the FPPC was the fact that, they thought that it was all creatively written. You had an appointing power spread out, so the governor just got the chair, and then the controller got a spot, and everybody kind of got a spot, so no one could have undue influence. But the weakness in that setup is the budget. That who approves the budget for the FPPC? And the answer is the governor. The governor approves the budget. And where's the oversight on the budget? If the chair of the FPPC says, hey, governor, I need more money, and the governor says, sorry, it's a tight year, no, nothing happens. There's no oversight. And unless you can fix the budget problem of funding the FPPC, it's not really going to give it the independence that it really needs. And finally, one final thought on the PRA. We talk about Form 700s. I think it was Karen who said there's more than 100,000 Form 700 submitted, 300,000. Nobody looks at them. They all go into a file folder. Nobody sees them. There's no responsibility or accountability for anybody in those agencies to actually even look at them. And now all we're left with is some level of disclosure. We hope the press corps pays attention, but Yeah, it all goes away. Without some responsibility for those Form 700s, it's a fake disclosure requirement for the most part. Finally, let me talk about the press corps today and their ability to oversee, the work of government leaders, be a check on corruption. And it's been said earlier, I'm sure you know this, the decimation of the press corps. A third of all publications in California closed in the last 25 years. 65% of journalists lost their jobs in the last 20 years here in California, that there's this caving in. And it's a serious problem in holding governmental officials accountable. I was just on Friday night able to watch a brand new documentary. It's called Stripped for Parts, Journalism on the Brink. Was with producer Rick Goldsmith. And it was about how, what has contributed to the hollowing out of newsrooms in our country, the hedge funds buying them up for their property, not really caring about the important work of journalism, just wanting their building or their property to strip for parts and then sell off. And of course, for those who have followed the work this past year in trying to find a way to refund, to restore journalism in California, you know about my work and others to try to apply pressure to the places where that really contributed to the hollowing out of newsrooms, which is the advertising, the loss of advertising. These platforms, these social media platforms have taken your data and they've used it to become the place to go for advertising because they know all about you. And our traditional sources can't compete in that space and what we can do about it. But it's a serious problem. Every major city in California has had a corruption crisis in the last 10 years. The New York Times, I know, did a story. I'm sure it created some chagrin by our California reporters about the cities of corruption here on the West Coast. It's a very serious problem, and it's not an easy one to get out of. And I know it's not the purpose of this seminar today. But I want to just say that what these reporters do is so important to keeping us accountable. And I know we're going to hear from them about that because they come with great experience and insight that we will benefit from. And it contributes to, the reason this is so frustrating for me to be here, and maybe not so much for Gail, Assemblymember Pellerin, is that this is it for me. I've done my 10 years in the legislature. And coming to seminars like this, it's always about, okay, you hear about a problem, let's figure out a way to solve it. And for me, that opportunity won't be there. The Political Reform Act came about because of a wave of Watergate. And waves have been how policy has changed in our state. Tax policy comes from a wave. Crime policy comes from a wave. Whether we get a new wave again that we can take these reforms and make the change that we all know happen is to be seen. It almost can't happen in the legislative process because it's asking us to do things that create oversight over us and find out our foibles and our problems. And so while I hope that there'll be leadership in the legislature to try to advance these reforms, some of which I've talked about, it's going to depend on whether folks here in the room can highlight it and can find ways to lead so you can catch that next wave to make our government and our democracy better. And with that, I look forward to the panel today.
Senator Glazer will be having a fundraiser at my UL at 5 o'clock. Sorry, couldn't help myself. Thanks very much for allowing me to be part of this. Yeah, it's the obituary journalism on my end from my years in the press corps and now working for a public agency. I invite all of you to look at my Form 700 because while journalism is not exactly a vow of poverty, when I first filled it out, I'm like, do you really want this? Anyway, it's an exciting read, Laura, Tara, and I commend you to it. Let me introduce the panel here for a second, and I just figure we'll make our way through some kind of, not only the topics probably that you've talked about a little bit, but I'm especially interested from the Fourth Estate viewpoint of this, and the press spends such an enormous amount of time as a watchdog on money and ethics in politics. So it's great to be here with them. Down at the farthest end is Taryn Luna, my former colleague from the Los Angeles Times, who I was lucky enough to hire many years ago, worked at the Sacramento Bee, worked in Boston. Laura Court, next to her, who is the ace at Politico, writes the morning newsletter. Should I give a plug?
Yes, please.
Plug away.
You can subscribe to the newsletter and get it in your inbox at 6 a.m. every morning at Politico.com.
It's going to tick off everybody else, but I did it. What the heck? Laura writes that, co-writes the playbook, and obviously worked at the Sacramento Bee before. And last but not least, the always irascible, voluminous.
Another obituary.
No, come on. I'm giving you the mic here in about 30 seconds. Hang on. Dan Walters, who legendary columnist, a long time for the Sacramento Bee and Cal Matters the last several years. So thank all of you, and thank you for letting me be a part of this as well. So everyone clearly came in. And, it's so funny. I'm like, I bet no one will do the whole 2 hamburgers and a Coke. Everybody did the damn thing. So that's just kind of, do it too. I know, throwing the notes right out the door. I did, however, perhaps be the only person who determined that the 2 hamburgers and a Coke of 1974 is now about $16.
Yeah. Oh, yeah.
I still don't think that gets to the problem, which is probably Senator Glazer's point earlier. Easy 16? Yeah. I was mindful, though, that Governor Brown cut a commercial when he wasn't Governor Brown, when he was Secretary of State Brown running for governor in '74, because I went back and looked at it, and there's a quote about it was a new law he was talking that will cut those fancy expense accounts. And it did, but I think to the point that Senator Glazer made and things we want to talk about, influence and by extension money and by extension law writing happens in so many other places other than that one time of buying somebody lunch or buying somebody dinner. So Dan, let me roll back to the good old days of 1974. I will not tell you how old I was, but I was here, so that's something. Talk a little bit about the environment that Prop 9, your viewpoint from a journalist, the environment of Prop 9's passage. Obviously, there was a massive national story that played out, but I'm curious whether there was a discontent in California, or was that really riding the wave of national outrage?
Yes, that was riding the wave of national outrage. I'll take you back to 1975. Well, I'll take you back to 1974 and then 75. 74, of course, the Political Reform Act was passed, sponsored by Jerry Brown, then the Secretary of State, on the June election in 1974, which in itself is a little story because Jerry bent the rules on ballot measures, and when they had to go on the ballot, since he was Secretary of State, I guess he figured he was entitled to bend the rules to put that measure on the June ballot rather than on the November ballot when he would be of course, running for governor on the November ballot. That's just a little footnote to history. But at any rate, the Capitol in 1974 was a different place than it is now in many respects. First of all, it was the old Capitol, which a year later they ripped apart it and built a whole new Capitol inside the old building. But it was a kind of a, I would say, fraternity, because 99% of the members of the legislature were men. Probably 90% were white men, and virtually all of them were either middle-aged or elderly. In fact, one state senator, Ralph Dills, was first elected to the legislature the same year Jerry Brown was born, in 1938. And a lot of those guys had been there, I say guys because they were almost all guys. The Senate didn't get their first woman member until 1976. Those guys had been there a long time. They were a fraternity. They were pals. They were friends. And it had very little to do with party in those days, oddly enough, considering what happened later. It was almost not nonpartisan, but it was more of a bipartisan sort of thing. There were conservative Democrats. There were liberal Republicans. Some of the Republicans were more liberal than some of the Democrats. But it was really kind of a clubby sort of place. And part of that clubbiness were the lobbyists, who tended to be what? White, middle-aged, or elderly men. And they were all pals, and they hung out together all the time at the various watering holes around the Capitol, most famously, of course, Frank Fatts, where later, some years later, a thing called the napkin deal was put together. That's a whole other story. But not only Frank Fatts, there was Posey's, there was the building that housed the press corps. What do you call it? I can't remember. Ellis's. And it was on the lower level of that building, 10th and L, and it was known, the elevator had LL in it, which was lower level, but everybody called it the liquor level. because it was mostly a bar. And then right next door was Capitol Tamale, where the California Teachers Association building is now, was a thing called Capitol Tamale, which was another hangout. There were about 4 or 5 places around the Capitol that you could find legislators and lobbyists together all the time. There was a thing over at Posey's called the Derby Club. The Derby Club was legislators and lobbyists who got together, I think once a week, with the lobbyists picking up the bill, of course, for lunch, and they had a lot of drinks and a lot of luncheon, and they played games with each other, and it was all very convivial. I could tell you a wonderful story, Derby Club story, but it would take too long to actually do it. But there was another thing called moose milk, which was very similar to the Derby Club. By the way, the Derby Club got its name because a bunch of legislators and lobbyists were in New York City, and one of them bought a derby hat, and so they decided they all should buy derby hats. And they all had derby hats, and those derby hats were on display in Posey's restaurant, the seat of the Derby Club. So my point is that was the atmosphere in the Capitol at that time. It was male, it was white, it was middle-aged, elderly. They were all kind of sang from the same song, same hymnal in a way.
Are you saying it was ripe for something to?
Well, I don't know whether it was right. I don't know that it was terribly corrupt in the usual sense that we think of corruption. It was more just that's the way it was. It was the atmosphere of the place. You did things for your friends. Did their friends buy you lunch once in a while? Yeah, they did. But you had probably done the same thing for them whether they bought you lunch or not. It was truly had a fraternity atmosphere, including all the hijinks that went on after hours, just like a fraternity. But like in Las Vegas, everything that happened in Sacramento stayed in Sacramento, right? Yeah. I knew one legislator who had 3 women on the hook. He had a wife down in the Riverside, he had a girlfriend down in Riverside, then he had a girlfriend up in Sacramento who was a lobbyist. And how do you deal with that kind of thing? There was another legislator I wrote about, but the point is,
I love you, Dan, but bring it home, baby.
The point is that was the atmosphere of the place. And then this young punk Jerry Brown comes along, as that's what they thought he was, who they liked Pat. They didn't like Jerry at all. And they didn't like him anyway. And he was not a very likable person in those days, believe me. But they certainly didn't like him when he passed this Political Reform Act. And they had to do all this stuff that they didn't want to do, and it was just a pain in the ass. The most interesting thing that came out in the early days of the Political Reform Act, to me anyway, was there was a lobbyist and a legislator. They both had dogs, and one was going to breed his dog to the other dog, and I can't remember which one was which. So they actually had to go to the Fair Political Practice Commission and decide whether that represented a gift or not. And that's the kind of stuff.
Jake, what's the value of such a gift? Could you please tell us?
Anyway, that was just what I tell you. That's well. Let me say one more thing. As a result, they disliked Jerry Brown so much that they did everything they could for the next 8 years to thwart anything he wanted to do, and he lost a lot of his legislative agenda by the fact that he had sponsored this Political Reform Act, and the legislators, the lobbyists, considered him to be a snot-nosed kid who didn't know what he was talking about.
So Laura's already finished the playbook for tomorrow morning now. She's got a good one here about the Posey room. Is it the Posey room? I digress.
Derby hats, dog breeding. Yeah,
this is good.
The good old days.
There's another there really is a podcast in this. I digress. I mean, one of the things that, and let me pivot to my friends down the other end here. So Laura, let me go to you and then to Taryn. You guys can both take a look at this. When we look at the Political Reform Act, we know it did a variety of things, and it launched a variety of conversations in California. California goes, so goes the country. Government ethics is one. I want to talk about campaign money. I want to talk about money in politics. And I want to talk about just from a modern day perspective, and maybe we'll find a way to kind of weave it back to whether the Political Reform Act has upheld the promise that it made to the voters. I would make an argument that a lot of ballot measures in California don't necessarily meet the promise that the voters were given. That's another podcast. But what do you think, and Laura, let me start with you. What do you think is the current state of money in politics? Is it an accepted part where everybody knows the rules? Do you find that the people still try to find creative ways around the rules in your reporting? And what do you think the voters believe? Is it an accepted fact, everybody's got money in politics, everybody's raising money?
Yeah, I mean, I think money is incredibly important. It's always been important. And I think that, the public, perhaps as they get more information, has become increasingly cynical about that fact. I don't think anybody is blind to the reality that there are laws, but to your point, people get creative more and more, every year. And we have these, campaign contribution limits, which came out of the Political Reform Act. But something that I'm always interested in is kind of understanding, there's infrastructures behind all of this fundraising that goes on, all these contributions. There are certain laws around, coordinating among groups and, having to aggregate contributions if it comes from the same sort of place. We've seen that with some groups, but there's still a lot that I think you don't know unless you are somebody who is watching this every day, and I think that's why the public gets incredibly cynical about it. And I mean, we've seen this with everything from religion to schools, right? That the public just does not trust institutions anymore, and I think that the money and the perhaps creative accounting around it is a big part of that.
Taryn, what do you think is the most fertile ground that people till these days for money in politics when they want to have influence, show influence, gain influence?
I'm still processing. I don't know if this is on.
Do you want to use mine?
Yeah. I was still processing 3 women and dog breeding, but I think that it's produced more information. We now have a better sense of what lobbyists are doing and who's paying to influence. I think some of the problem that we run into as journalists is the accessibility of that information, right? I know Power Search has made information more available, but we're looking at Form 700s. You have to pull up a PDF and go through it extensively. Then
Is this where we talk about Cal Access, but we'll get there?
We're not going to go there today. So I think that we have more information than we had in the past, but I think it's still very difficult to use that information. And so I think that's part of the challenge that we as journalists face. I think we've seen some positive things come out, right? So the reality now that on ads on television or online, you have to display the top 3 donors, and it can't just be a group like Californians who love the environment and it's really a bunch of oil companies, right? So now we have to actually see who's putting money into these campaigns. And I do think, and some of you in the room might know better than me, that kind of changes calculations in terms of who these top 3 donors are going to be to a campaign, or a more thoughtful consideration about that because it's going to be out there. But I still think, for us, the big issue is accessibility. And, when I started at the SAC-B, we had a reporter named Jim Miller. And every quarter he would go through the reports, and it was the only time I heard Jim swear. But he spent a lot of time going through, and we'd write stories about which group or which company was paying to influence the most. And those reporters just don't really exist in the same capacity anymore. We don't have that person at the LA Times now. I don't think the SAC-B has that person either. So it puts a lot of onus on individual reporters to sort through that information. And when you're getting pressure to write about the news of the day or some hot topic that's trending online in relationship to the California legislature, it is hard to make the case to take a day or two to go through that information in a thorough way. So I think we have more information. The problem is then taking that information and getting it out to the public, or being able to use it in a way that makes a difference.
It's a really good point, because information is one thing, but absent it being accessible and understandable, it doesn't do anything. And it doesn't pay off on the promise that the voters have continually been told they are taking action on, right? Prop 9 in 74, Prop 73 in 1998, Prop 208 in 1996, Prop 34, which is an interesting story into itself, in 2000. But every time the voters are told, take action, and absent this key element of accessibility, is what you're saying, they don't get it.
This is where I get to give my plug.
Okay, go your plug.
I work for Cal Matters, and by the way, we have more people covering the Capitol than everybody else combined. When I went to work for Cal Matters 7 years ago, I was like employee number 10. Now we have 100, and not all of them are journalists, but most of them are. Anyway, here's my plug. Very recently, Cal Matters teamed up with some people down at Cal Poly San Luis Obispo to create a thing called digital democracy. Write that down, digital democracy, because you can put it in Google and find it. And it takes all the data that's available, everything, and pumps it into one place. and you can access it. Doesn't cost anything. For example, you can get a bill in there. The bill, you not only get all the stuff about the text of the bill, the analysis of the bill, the votes on the bill, but it'll take you to the point in every hearing where that bill was discussed and not only show you that thing, but print it out for you in text, what's being said about that bill at that hearing. It has everything you can possibly imagine that's available is in this thing, and when the 700 reports go online, those will all be in there. We have a profile of every single legislator, and we'll put all that stuff in for every single legislator. It's a magnificent tool. Digital democracy, check it out. It is fabulous, truly is. It's the thing that they were talking about, that it's all in one place now.
Go ahead.
I have a small anecdote about this because I think digital democracy is great to the point about accessibility. And in fact, I had run into your Cal Matters, Dave Lesher, when he was telling me about this project that they're doing with Form 700s and, enlisting students at Cal Poly to, it sounds like, manually enter every bit of detail from the Form 700s, which is crazy. Because at the time that I ran into Dave Lesher and was asking him about this, I was working on a Form 700 project and losing my mind because it is going through PDFs and trying to reconcile information that is not necessarily uniform. It took me several months to do this project on lawmakers accepting tickets as gifts. You can read it if you would like to. But that was something that I ran into where it was just like incredibly tedious. And so had there been, the digital democracy project, I think that would have been incredibly helpful. And I look forward to, those are stories that could have gotten done in a week instead of 4 months.
We're actually using it. By the way, it's all driven by AI. And we actually have, not having a reporter look through those things, we have reporters who now use that to look through all of those financial reports, everything they can, and are producing stories out of that right now.
So let me, interject this about digital democracy. It's a great tool. As I said to Dan over there, you need journalists to actually then use it.
Yes.
Because the public's not going to use it. You're going to need enough journalists. So, here's a plug for supporting some form of journalism in your life, ladies and gentlemen. But Laura, you were talking about an effort you wrote. I remember your story, your look at gifts. And I want to talk about the whole, again, looking at the Political Reform Act, money, gifts, ethics, lobbying, influence. There are a lot of topics under the larger umbrella of influence in government and politics. Mm-hmm. What's the takeaway, do you think, of the state of gift giving? What do gifts tell you? What do you think the gifts tells the reader? And I know Taryn's done some work on this past. I probably assigned her something on this in the past. But what do you think it tells the reader? What do you think it tells the public? What's the larger story?
I think the larger story is understanding where relationships are being built, because you can talk about, campaign contributions coming from a group, but when you see gifts sometimes, especially the area I was looking at with tickets, it does convey a certain level of a relationship building. And, there were even groups that I spoke to who said, that's a specific part of how we make sure the lawmakers who represent our district know what's going on inside our businesses and are able to come and see it. And so I think the state of gift giving, I had talked to Dan Schnur, a former FPPC chair, about this for the story. He said a donation's one thing, a phone call's another thing, but if I take a lawmaker to a baseball game or if I take them to a concert, then I have a friend who's always going to pick up my calls. And so I think that is so key to understanding who is talking to lawmakers in probably one of the more personal ways than, this is not taking a meeting at your office in the swing space. This is perhaps, having a couple of beers and a hot dog at a Dodgers game, which is much different, and I think conveys a much different kind of relationship. The thing that we also look for a lot, and I know lots of folks have done stories on this, Form 700s include trips that lawmakers go on, which is also very critical. I always look forward to March because I can see where lawmakers were going during their recesses. There are some trips happening right now as we're in this kind of intermittent time. And so, I think it's really eye-opening and just more colorful, I think, as a journalist, more exciting to cover what's in those Form 700s and what's going on with gifts.
Taryn, safe to say that access becomes like the story in some way. Would you agree with that?
Yeah, I think access is the story. I think for journalists too, right? For a lot of us, we have very strict limits on the kind of gifts we can take from sources. There's, some are $25, some are none, right? So when you look at someone getting, tickets to a Taylor Swift concert that could be valued at however much, it shows a different relationship, right? So I think there's always a question in my mind of why the gifts are allowed, why the gifts continue, and if we're really trying to, get a hold of influence and take a look at it, I think that's a question that should continue to be explored.
I want to talk a little bit about the lobbying end of the world that you all cover. A lot of the conversation in years past has been about revolving doors, people who go from elected office into the third house. Some of it, of course, is gifts, which we already kind of talked about. But here, too, it's a challenging place to tell what those relationships are and to understand what those relationships are. And I mean, isn't there a danger, and I'm going to play the other side of this for a moment, which is that all relationships aren't bad. Relationships can help govern more effectively. And how do we tease this out? Maybe I'll go back your way because you've seen this play itself out back from the days of dog breeding and other parts that we won't go to. But how do you suss out for the public, because there is a sense, if I can, of a public that can be overly cynical and jaded about government. Yeah. And you have to find the context for this.
You have to make the relationship, and that's plug for digital democracy. You make the connection between the legislation, the vote, the money, the gifts. You make that connection, and some of those are quite innocent, and some of them aren't so innocent. But if you look at it in context, the pattern comes out. Now, I got to tell you another old war story. So there was this legislator who was carrying legislation on behalf of 3M Company to mandate that 3M materials be used on reflectorized license plates. A lot of money. Well, he took a trip to Hawaii with the lobbyist for 3M, a young woman, and when I called him about it and teased it all out, he says, well, it was okay because it was a bona fide dating relationship, he said. Therefore, it was legal. Now, that's the sort of stuff that you have to try to figure out. Those kind of relationships, and you have to, the action, the legislation, the vote. I was writing a story 40 years ago. I was trying to figure out how one bill got passed. And it was a bill that allowed podiatrists to conduct surgery on the ankle. And it was opposed by the doctors, the orthopedic surgeons. So I had everything out on 3x5 cards, because that's the only way you could do it then. There were no computers even. And every vote on that bill, every campaign contribution made, and I had it all figured out except for one legislator who never voted on the bill, but he had gotten a bunch of money from the podiatrists. And so I wrote this story, and then years later, the lobbyist for the podiatrist and I were acquainted, and I just asked him, okay, why did you give that $5,000 to that guy? He said it was very simple. The bill got over into the Senate, and the bill could be assigned by the Rules Committee to either the Business and Professions Committee or the Health Committee. And we wanted it to go to the Health Committee because we knew the docs had the Business and Professions Committee wired and they could kill the bill. So the guy who got the money was the chairman of the Business and Professions Committee. And so he was paid $5,000 simply not to ask for jurisdiction on the bill so that it would go to the Health Committee. Now, how do you figure that stuff out? That's tricky. But it's very, very indicative of how business is actually conducted. It's not always a vote. It's not always a carrying a bill. It's some gesture like not doing something. And it's very, very difficult to figure those connections out. It's easier now because we do have access to campaign finance records and votes on bills that you don't have to put on 3x5 cards. But that's the real business. When you get down to the nitty-gritty of why legislation passes and why it doesn't, it's very difficult to actually figure out why some of these happen. And we all know about the appropriations committees, right? The most important bills go to the appropriation committees in both houses. And then the chairman of these committees just simply announce which bills are going to the floor and which are not. So most these decisions are made somewhere in the bowels of the Capitol by somebody. There's no record of it, really, who made the decision. Even the authors of the bills don't know who makes the decision or why it was made. How do you get that out of the system when it's buried that deeply into the bowels of the Capitol? I don't know.
I would argue you don't. So a lot of the information and tips that I get come from people in the Capitol community. And then I use that information and work backwards, right? So I pull up a forum to understand when this fundraiser happened or who is contributing to who to see if there's anything to back that up. But there are very seldom, not very often am I going through reports, coming up with some great story that's, a real gotcha and flipping it the next day, right? So a lot of times you end up hearing things, you do the old-fashioned reporting that we've all been accustomed to doing, and then you use that as a backup method. And I think in reality, we as in, you guys at the FPPC and the legislature can pass as many reforms as they want, but there's a part of this that's always going to be opaque, and there's a part of it that only journalists and the lobbyists and the people in the know will be able to suss out. And so, that goes to the reality of the way that the press corps has been cut back over the years and the challenges there. But I personally don't rely on the system or the information available through reporting around campaign finance to tell me what's going on. I think another aspect of that is the reality of the revolving door, right? And so there's a limit to how quickly you can turn around and be a lobbyist if you're a legislator. Well, you can always be a consultant, and that is a massive gray area to me. I know there's
But that's a relatively new phenomenon in the arc of this conversation, but yeah, you're right.
Yeah, but I mean, as a consultant, I can get all the way up to the line of lobbying and have, the lobbyist in my office go make that final pitch and deliver it, right? But it's really challenging to kind of suss out what consultants are doing, and in some ways, they can just kind of hide in the dark. And we've seen FPC investigations try to get at that, but I think you have to have, more authority to investigate it than a lot of us do.
Were you going to say something?
Yeah, I would just add, I think that's completely right, that there's always going to be ways to do these decisions in the dark. When I came to California, I was in Texas before this and understood the suspense file and how bills can be killed without really even an explanation. It's pretty shocking. John, to your point about the public being really cynical about government and these relationships, because this is in many ways how politics works and how a lot of businesses in the world runs, right, through these relationships. And it's no secret, that Sacramento it's a very small community. This was an issue that came up, I believe, last year when State Senator Aisha Wahab introduced a bill to prevent staffers from leaving the building and going straight into lobbying. And that got a lot of pushback. And there were some labor issues involved there. Folks were concerned about, if I get fired for something or if there's retaliation, how am I supposed to go make money? Because this is the only thing I know how to do. And so I think there's a certain understanding that everybody exists in this world and goes in and out. For me as a journalist, I try and weigh that. I try and, be understanding that, every contribution, every relationship is not going to indicate corruption per se. But the important thing for me is making sure people know that we're watching them and making sure people know that I am looking very critically at the things that you are spending your money on, the relationships that you're building, because I think even having that presence of a watchdog can make a huge difference. And it, goes to the point about the importance of journalism and the atrophying of the press corps. Having just eyes on the situation and having access to this information is so critical just for, I think, maintaining a certain level of integrity.
Yeah, a couple of small, brief observations. Number one, I think that the revolving door has calmed down over the years. I don't think as many legislators go into lobbying as they once did, in my experience. There used to be all over the place, but you don't see it so much. The second thing I want to mention is when the Political Reform Act was passed in 1974, not very much money was spent on legislative campaigns in those days. The first $100,000 campaign for the Assembly didn't happen until 1972. And most legislators actually could finance their campaigns fairly easy from their district. You know, a few spaghetti feeds or a crab feed or something, and they did it. It didn't cost much. A typical campaign for the legislature in those days was $50,000, maybe $25,000, $50,000. Now we have multi-million-dollar campaigns. And what happened was the speakership battle that occurred in 1980, where two factions of Democrats battled bitterly for a year over the speakership, Howard Berman and Leo McCarthy. Both sides spent tremendous amounts of money trying to get their guys elected. And as one guy was involved in it, he said, we found out that we could go to the lobbyist and get a lot of money. We never knew that before. That we could hit these guys for big time money, and they were willing to do it. It was a great revelation, 1980. And it's just grown from that point since. But campaigns were not a particularly expensive thing at one time in California.
Well, so that's a pretty good transition where I was going. I want to tell my friends here on the panel that I want to talk about, we're in a campaign season. What are you watching now? What do you think the stories are? What do you think those issues are? But I would just, again, point of personal privilege back to Dan, I would agree that the revolving door for legislators to lobbying has probably slowed, but Taryn made the point that kind of hit it on the head for me, in part because you are more regulated as a lobbyist than you are as a consultant, as an advisor. There's always a way. There's some smart lawyers in here too, and you know, you're the ones that I always wanted to call, and now, damn it, I don't know where to call you. But like, there's always a way, if you read the statutes, you read the provisions, that you can figure this out. And consulting, I would argue, is one of those that has popped up in that recent time because it's a much more pliable universe than is actually being a registered lobbyist. But
because to register takes,
yes.
You have to do certain things to
yes.
to be registered. If you just don't do those things, you don't have to register.
You and I are on the same page.
You don't have to report, and I can't go back to 1980, but I can tell you guys that in 2022, when we had a mass exodus of lawmakers, several of them went into the lobbying industry or were consultants for a while. So we have seen that in recent years.
Yeah, and can find ways in between those two titles or those two things.
Right.
So let's talk campaign season here again. Let me go to Laura, maybe if I can start with you. It's a busy season. You're everywhere, trying to be everywhere. As far as California, legislative races, ballot measures. Ballot measures could spend a whole bunch of time on, right? Because it's a different world of money and influence in politics, right? And we used to think about it in terms of groups, but there are also all these fascinating characters, you know, the Michael Weinsteins, who followed the Tom Steyers, who followed the Reed Hastings, bear with me. But like, there's so much to look at in the ballot measure universe. Is that a place that you're spending time this campaign season too? Do legislative races with their caps of limitations kind of hit the radar?
So boring.
Yeah,
no, of course,
guys.
Legislative races are always exciting. I will say that they do sometimes take a bit of a backseat just because the supermajority is not going anywhere, and so.
Right.
But no, ballot measures are hugely important, especially in California, and the money that is spent on them is just wild. At Politico California, we actually hired an editor and 2 ballot measure reporters just to focus on ballot measures, and that's year-round, not even during campaigns, because I'm sure, as you know, John, this spending and this kind of coalition building happens in off years as well. And so, yeah, we're absolutely watching the Prop 33 and the Weinstein issue, and then the kind of bizarre companion measure to that, Prop 34, which is going after Michael Weinstein and his AIDS Healthcare Foundation. It's been very interesting to see ballot measures become this kind of tool of politics, which I know sounds obvious to say, but you know, ballot measures used to be really meant, or I think they were intended to be a tool of direct democracy for folks. If lawmakers wouldn't pass legislation, voters could introduce legislation themselves, get enough signatures and get it on the ballot and get it to a statewide vote. But we're really seeing so much money pour in from these corporations, especially, sometimes corporations who don't get their way in the legislature will instead take that issue to the voters in a ballot measure. And so, yeah, it's just another really critical area of influence that's happening year-round, but especially this year. We're also watching, bonds happening. There's a climate bond, there's an education bond. There was the big fight over, certain reforms to Prop 47. That's now Prop 36. I know everybody knows all these numbers, I'm sure. Yeah, no, ballot measure is absolutely critical, I think, in the broad scheme of things compared to legislative races.
And the spending can be at these ginormous limits or ginormous amounts because the limits do not apply in the way they apply in those candidate races, which
Right.
which I would say is a fascinating part, is it not? We're all California journalists. We write laws at the ballot box in this state more and more and more, but we don't control the spending the same way as we do of the people who write laws the other way. I mean, there's a really fascinating
Totally.
influence game out of that.
Yeah, absolutely. I think that plays a huge part, and you see these campaigns get, up to over the, $100 million very frequently. Yeah, that's a very good point.
What are you watching this season, Taryn?
Don't tell my new boss, but after covering
your old boss.
a recall and an election, I covered the governor over the last 3 years. I was really not looking forward to another election cycle. And for me, a lot of the big things I covered got settled in deal making prior to the June deadline. So I was following the tax measure that got negotiated, or not negotiated off, actually, the Supreme Court intervened. And then, some of the things around oil setbacks. I've been asked to pay a little attention to some of the legislative races, so swing districts like 80-40 or SD 23 areas where we're seeing the parties really fight back and forth. So paying a little bit of attention to those too.
What are you watching, Mr. Walters?
I watch everything.
Okay, I knew that was the answer.
I just want to make an observation about ballot measures, which have become the almost basic tool of policymaking in California. Look, most important legislation and most important ballot measures deal with one thing: money. They take it from somebody and give it to somebody else, basically. And so either through taxation, through changing rules and everything, but it's money. And huge amounts of money, and that's true of legislation, and it's true of ballot measures. The equation is a return on investment. If you can influence billions, why not spend hundreds of millions? Like those two gambling things, the two sports gambling things a couple of years ago. What were the stakes in that thing? We were talking immense amounts of money. What they spent on those ballot measures was pocket lint compared to the stakes. And that's also true in the legislative process. A comma here, a change of word over there can have immense financial consequences for somebody. And therefore, if you are on the receiving end or the dishing out end of that equation, you're going to want to spend money to protect your interest. And the amount of money spent on campaign contributions and lobbying expenses and ballot measures, while it sounds immense, and it may be, $1 billion every 2 years or something, is nothing. Absolutely nothing compared to who gets a share of a $300 billion a year budget, which tax will be raised, which tax will not be raised, what company will be given some sort of a monopoly over this thing, like operating on the ankle for the podiatrist.
Yeah, but let me ask
Huge amounts of money.
But let me ask you, Dan, and ask all of you here, because this gets us kind of full circle where we started with the Political Reform Act now in its 51st year coming up. Is there a constituency for reform? And I ask that because, in this state, to effect change, you have to have a microphone, and that costs you money, and that costs you campaign. In other words, is there a constituency really for reform? I mean, when my head went when Dan was talking just then, it went to the way that we now have found everybody using the referendum process. Right? We stop a bill we don't like in the Capitol. We have it suspended until we have the next election. We may or may not actually run the campaign on the referendum because you can pull it off the ballot at the 131-day mark. So we found all these new ways, but and so back to the Political Reform Act, the constituency reform maybe was Jerry Brown's own political ambitions. That's great. Hamburgers and a Coke. He had the name, the ID. He had smart people who helped. He had a group of reformers who's working.
Very narrow election.
Yeah, but a group of reformers who he's working with, Bob and others. I mean, there was, the world was different. Is there a constituency for reform of these things? And this is like the cocktail hour where if we'd be really sad and depressed, we can go to one of the bars that Dan named and drown our sorrows in it. But is there a constituency for reform? Are there activists that we should be looking for? Are there movements? Are there
I think in the ballot measure space as well as with referendums, it's something we've seen the business community take advantage to use as a check of some sort against a Democratic legislature, right? And I think that they have used that rather intelligently in their favor. I think over this last year, 2 years, we saw labor push back on that in a big way and try to make laws that would essentially make it harder for them to go to the ballot or give more time to negotiate them off the ballot and things like that. So I think, you know, labor with a built-in force of people who can go knock on doors and who also have a lot of money to spend are some, you know, is one of the ways in which you can check that. But I mean, I think when you're looking at ballot measures and direct democracy, you know, there's a lot of arguments the process doesn't work the way it was intended, right? The idea was for regular people to be able to pass laws or go to the ballot to check the legislature. And we see businesses do that, but I mean, I haven't seen one that's coming directly from the people, you know, maybe one very wealthy individual with a lot of money, but directly from kind of grassroots individuals in a long time.
Yeah, I mean, Laura, you alluded to this too, that the people's power through the ballot measure is no longer really kind of the people in that way.
Yeah, absolutely. And I think there have been certain conversations in recent years around, ways that make it a bit harder to qualify certain ballot measures. But, you know, in talking with folks about this, I can't remember who said it, but, you know, it's a very obvious observation that voters aren't going to vote to have less rights. They're not going to vote to make it harder for themselves to, enact ballot measures, even if it's a tool that's mostly being used by, you know, corporations, or you can be as cynical as you want about that. I think also there was a lot of conversation about reforming, like the recall process after Gavin Newsom's recall was qualified. There's, you know, conversations about raising the threshold and all things like this, and decreasing the timeline that you could gather signatures. There's always kind of jockeying around the rules on this. But I think that that's things that is not necessarily grassroots driven. I think that's, you know, corporations who are playing the kind of long game here, or interest groups. I've used corporations too broadly there.
And all it takes is another ballot measure to change the system. We got to wrap, so give me the 20-second version.
If you change the rules of the game, whether it's baseball, football, or politics, you change the outcome of the game. When Buster Posey got spiked at home plate, they changed the way the runners can slide into home plate. You change the outlet. And so when you talk about reform, you have to understand that those reforms are going to change the outcome of the game, not merely the process that we get there.
I want to thank the group here, and I want to use my soapbox for the 25 seconds. The two things that come back to money, since we talk about money and politics and influence, that I found as a reporter through all the many years here, are the following. One, Dan alluded to it earlier, the funding for enforcement is appallingly low. I can say that now, can I? I could be a columnist. Well, it's appallingly low. I wrote a story years ago when Leanne Randolph was chair of the FPPC, I think after Karen, about the budget cuts and the backlog of enforcement actions, and there was no one to do them because no one wants to pay for, you know, enforcement. And the other one is nobody has paid enough for journalism. And that's where I do go back to it, because if you don't have somebody watching, if you don't pay, it won't be around. So I would urge you to find a way to support someone who is watching. To Laura's very good point, knowing that someone is watching has a tremendous impact. And I think that's kind of one of the legacies of the Political Reform Act, is that, you know, accountability matters. So Taryn, Lauren, Dan, thank you all. Thanks for having this great event. Thanks so much.
Once again, thank you, Taryn, Laura, Dan, John. Thanks. Appreciate you being here today. And before we close, we have some final thoughts on this subject from, I guess, the star of our show today, former Governor Jerry Brown.
So it sounds like, I mean, I could talk to you for hours and hours. It sounds like we're coming to the end of our time. I just wanted to thank you so much for meeting with us today, inviting me up here to your beautiful home. Thanks again, Governor. Really appreciate it.
It's good. 50 years. I did a lot of stuff that's having their 50th anniversary. So I think it's a time to reflect what it is. And you don't want to reflect too much. You've got to think about the future. But it is the nature of law. What is law all about? And law has really changed There was a guy, not a great guy, but anyway, he's a very impressive jurist. He talked about motorized legislation. 150 years ago, the courts decided things, and then they started writing codes, the field code in California. And now you have, instead of a judge sitting there deciding, are you liable, how much are you liable, now you have it all done essentially by legislators. But legislators can't consider 3,000 bills a year. It's impossible. So they depend upon the staff. The staff can't figure it out either. They depend upon the lobbyists, the interest groups. So the interest groups are powerfully shaping our world. And I think the more you understand that, then the more you can understand what you should do and then what you can do as chairman of this very important body, the Fair Political Practices Commission.
Well, thank you. I really appreciate that and for joining us today.
Okay. Good luck.
Thank you.
Thank you very much.
Oh, that was an excellent panel. Thank you again. I believe we got these microphones on. It's a lot of thank yous to do. I'd also like to recognize a few people, so hopefully you'll stay along for that. So first I want to thank all the panelists and moderators today. This was an excellent event. It wouldn't have happened without all of you. And speaking of some other indispensable parties, I want to thank McGeorge again for all the help that they've provided. In particular, Professor Aaron over here. She did an excellent job from the start. She just was on top of everything. And just thank you so much for your effort on this. Ryder, the IT team, Dean Schwartz, thank you as well. We really appreciate your help and your partnership in putting this event on. And in addition to that, I want to thank the California Broadcasters Association for sponsoring this important event. We really appreciate your support. And of course, I want to thank staff at the FPPC. I want to thank Cole Smith, Sasha Linker. I want to thank our IT group, Jesse and Elwin, who helped us with the video. Of course, I want to thank Jay, our MC, and someone who set up that interview, did so many things on this event, definitely would not have happened without him. And I want to thank our executive director, Galena West, who's about to celebrate her 5th anniversary as executive director. I don't know if that's ever happened before. So congratulations on that tenure. And speaking of the FPPC, well, before we get to them, definitely want to thank Governor Brown and his staff, especially Evan Westrup, for setting this all up. I want to thank Governor Newsom and his team for getting us that recorded message. I want to thank Senator Glazer and Assemblymember Pellerin for spending so much time here today. It's really amazing that you were willing to do that, and thank you so much. I really, really appreciate it, and the FPPC appreciates it. So with that, I do want to recognize 3 individuals, and this is going to be 3 indispensable public servants in my opinion. Well, let's make that 4. So we have 4 commissioners on the FPPC in addition to the chair. So we have Commissioner Dodson Wilson, Commissioner Catherine Baker, Abby Wood, and Elsa Ortiz. The reason why I said 3 is twofold. 1, I have the 3 of them right here, so I'm looking at them. And 2, their terms are coming up. And one thing that I want to mention is I feel like an FPPC commissioner, that is often referred to as a thankless job, right? So I want to take the opportunity to thank all of you for your service. It's really tremendous, and what you've been able to do over the past 4 years is just unbelievable. If you could stand and be recognized, I'd greatly appreciate it. I know you have a hurt ankle, Commissioner Baker. And one other thing I would mention, just to recognize their contribution to the commission, is a lot of the critiques that were levied today, whether it's in terms of enforcement or advice, the FPPC, under their leadership, identified them and actually took proactive steps to address that. So for example, in terms of the enforcement backlog, that's something that these commissioners identified, brought to the attention of staff, and subsequently the FPPC took measures such as introducing the PrEP program that we talked about and other measures that reduced that backlog by 41% in just 2 years. That's pretty significant, very notable. So there's that, there's expansion of our advice operations. We had a digital task force, I should say digital transparency task force, just some amazing things happened under your tenure. So thank you so much. And of course, your terms are not over. As Mr. Walters said, this isn't meant to be an obituary. I just wanted the opportunity to recognize you in front of this audience. So thanks again. And thank you everybody for joining us today.